Good morning, everybody. Welcome to the Boston Marathon edition of the Science, Technology, and Energy Committee meeting for April 15th. We'll begin our meeting as usual by joining Representative Munns as he leads us in the Pledge of Allegiance. Okay, we have a full agenda today. We have 4 public hearings this morning on the following bills. Senate Bill 595 FN relative to the rates for pole attachments. Senate Bill 603 relative to telephone number and area code conservation. Senate Bill 386 relative to establishing a committee to study power generation, transmission, distribution, and storage. And Senate Bill 449 relative to the permit issuance timeline for state air permits. After these public hearings are concluded, we will take a lunch break. And then at 2 o'clock this afternoon, we will return here for an executive session on 5 bills. Senate Bill 303 relative to the use of renewable energy funds by the Department of Energy. Senate Bill 388 relative to administration of utilities by the Department of Energy. Senate Bill 391 relative to electric grid interconnection for certain customer generators. Senate Bill 451 relative to an expedited track for certain applications to the Site Evaluation Committee. And Senate Bill 540 requiring the Department of Energy to investigate behind the meter and utility scale energy storage. That's our agenda for today. It's a busy one, so let's get started. And I'm going to open the public hearing on Senate Bill 595 FN and call forward Senator Avard, the prime sponsor of this bill. Good morning, Senator, and welcome.
Thank you, Mr. Chairman and committee members. I appreciate you being here. It's a beautiful day. Hope you had a great weekend. And if I have paint on me, it's because my wife had me doing chores. Oh my gosh. So I'm Senator Kevin Avard from District 12, representing Nashua Wards 1, 2, 5, in Brookline, Greenville, Hollis, Mason, New Ipswich, and Rindge, and I'm pleased to present this bill, SB 595, relative to the rates of pole attachments. 595 was unanimously voted on, ought to pass with amendment by the Senate, and I appreciate your consideration of this bill and ask you that you would vote for ought to pass as well. 595, as amended, is an important piece of legislation. And first, it aligns New Hampshire's administrative rules relative to pole attachment rates, which, with statute, by directing the Department of Energy to adopt formulas for use when resolving disputes between pole attachment owning utilities and entities like broadband providers, and attaching their networks to the poles. Secondly, it directs the agency to develop an accelerated dispute process, resolution process. As the Federal Communications and National Telecommunications Information Administration have confirmed, transparent predictability and fair pole attachment rates and accelerated dispute resolutions are key elements to good infrastructure development policy. That's a mouthful. Just saying. This bill is providing predictability, transparency, and certainty to a process that is critical to New Hampshire's goal of universal broadband access. The New Hampshire legislature has done great work in recent years adopting policies which speed and encourage broadband deployment, such as Part 2 of SB 88, which orders the Department of Energy to adopt FCC One-Touch Make-Ready rules. We should continue that effort by passing 595 as amended. Thank you, Mr. Chairman and committee members.
Thank you, Senator Avard. Questions for the senator? Representative Harrington has one.
Thank you, Chairman. Thank you for taking my question, Senator. Just trying to get this straight, because reading the text of the bill, it talks about the department, which I assume is the Department of Energy.
Correct.
Multiple times. But when you go to the fiscal note, it talks about the PUC. So who's doing what where? Can you just kind of straighten that out for us, please?
I'm gonna try. Yeah, I know, it is the PUC. I think it's, I'm trying to find out where, they set the rules and then, I think the PUC executes them. I'm trying to, just read that.
So just a follow-up. So what you're saying is then the Department of Energy will set on a non-adjudicative proceeding, set some rule out, and then it'll be up to the PUC to enforce the rule?
I believe so, yes, sir.
Okay. And does the PUC have any authority over non-utility attachments to poles?
That I'm not sure of. I do not know about that, but I know that they're, most likely, if you look at the fiscal note, they're gonna have to hire somebody to.
Right. You said, I'm just a little trying to see how that works out, but we'll save that question. then.
We'll
Thank you.
have testimony by the department in just a few minutes, so we can get some
Thank you.
clarification on that. Senator, would you say that it's basically true that what this legislation does is it gives the department, as opposed to the commission, the responsibility for developing the formula that's used for
Yes.
pole attachments? Is that correct? Okay, thank you. Further questions for Senator Avard? Representative Corman?
Thank you, Mr. Chairman. Hello, Senator.
Good morning.
So following up on Representative Harrington's question.
Yeah.
So the DOE would set the rules and the PUC would enforce. This seems the reverse of what normally happens. Doesn't the PUC usually set rules and the DOE enforce?
I'm just a pretty face. You're right.
Further questions? Seeing none, we want to thank you, Senator, for being here to introduce this legislation.
Thank you.
And now let's hear from the department. Amanda Noonan and David Shulock will give us their perspective and correct any misperceptions we may have about this legislation. Good morning to both of you and welcome.
Good morning.
Good morning. So I want to address first the question from Representative Harrington. Sorry, thank you from Representative Harrington about the fiscal note. The bill before you has been amended since this fiscal note was developed by the Public Utilities Commission, and we understand from them that this would no longer be an accurate fiscal note. I don't have an explanation for you as to why they haven't updated the fiscal note, but we do understand that this fiscal note is no longer accurate and that the commission would no longer need the resources that it listed in its fiscal note. As was noted, some of this work has transferred to the department to have a stakeholder session and develop a formula for pole attachment, resolving disputes between carriers about the appropriate rate for a pole attachment, and we'll present those to the commission for them to adopt rules. And it is currently typical that the department would set rules and/or policy, and if there were sanctions and enforcement actions to be taken, that would be done by the commission. So that's not a flip, it's the current paradigm. Having said all of that, the department is neutral on this bill. This is work that we can do within our current resources, and we're happy to help resolve this issue. I think there was a question about non-utility attachments to poles, and I don't know if Mr.
Yes,
Shulock-
Representative Harrington, repeat your question about that issue.
My question was on whether, obviously for the electric utilities, the PUC and DOE both have some kind of shared authority over that, but for communication lines that are not utilities, does either of those groups have the authority to tell those entities how to operate deal with pole attachments? I know the FCC has some authority, but I didn't know that the state did.
But we do have some limited authority, yes, but it's mostly exercised through the pole owners and their agreements.
Follow up. So in
Yes,
other
follow
words, in this case, it would be either I guess the telephone company or the electric company that owns the pole, and they would have agreements with the communication company, and that's how the DOE and PUC would have
Yeah.
some limited authority?
That's how the whole paradigm is set up. The agreements are, for the most part, voluntary between pole owners and attachers.
Okay, so this wouldn't change that then?
No, this doesn't really change that paradigm. The formula would be applied when there's a disagreement, when parties can't come to an agreement on what the price for an attachment should be, and the PUC has to step in to set rates. They would use the formula to do that rather than a 6-part test that they're currently using.
Okay, follow up?
Follow up?
I'm just a little concerned because I know the FCC has control over a cable line or an internet line, but I didn't think that the state had the authority, and unless we're granting them via this bill, to come in and say, okay, this is what you're going to charge based on this law.
We do have that authority.
You do. Okay, thank you.
Vice Chair Thomas has a question.
Thank you, Mr. Chair. Thank you for taking my question. For clarification, at least for me anyway, in the early part of the bill, it talks about that the commission shall use a pole attachment formula rather than a multi-part test. Could you describe the difference between the two? Why one versus the other?
So I don't have the current 6-part consideration for the pole attachment rates in front of me right now, but it's more than just a calculation of space on the pole and rate of return and so forth. It's more than just the calculation of the rate. There are other less quantifiable factors in that 6-part test. And so moving to just a formula-based pole attachment rate provides certainty to pole attachers.
Follow up?
Okay, so in other words, the current system is this multi-part test.
That's correct.
Okay, thank you.
Further questions? Representative McGee has one.
Good morning. Nice to see you all again. So it appears that there's a couple of different intents for the bill, and I'm wondering what the timing says around us meeting our obligation to the folks that are looking for this. Is the 18 months a reasonable amount of time to get to be setting how we're going to move forward and finalizing the formula? Because I think one of the intents here is to create some predictability and also to clarify that everyone who's attaching is receiving similar treatment, I guess. Is that an accurate assessment?
Yes, yes, that's an accurate summary of what it would do. We're comfortable with the amount of time that the department would have to accomplish what it needs to accomplish.
And in follow-up,
Follow up.
and I understand that we've got other bills where 18 months is also, a year and a half is also the time frame. But I guess what I'm asking is whether there is any sense of urgency or whether there is a need for any more expedient response to turning around the rulemaking. Whether the delays are actually causing any problems for the people who are current pole attachees.
So I'm sure you'll hear a testimony from some of the current pole attachees this morning. My understanding of, as Mr. Schulak identified earlier, the current structure is there are voluntary agreements entered into, negotiated between a pole attacher and a pole owner. This would be for when those entities can't come to an agreed upon solution. So I'll let them comment on whether there's any timing issues or sense of urgency for them.
Oh, can it follow up?
Okay.
So is what you're saying that there may be agreements that the pole owners and the pole attachees can come to outside of this process that can continue to go forward?
Yes.
And there would not be a delay waiting on this?
Correct.
Right,
That's
okay,
correct.
thanks. I thought that's what you were saying.
Representative Munns has a question.
Thank you, Mr. Chair, and thank you for being here this morning. I have heard conflicting opinions as to whether or not this bill would bring us more in line with the approach recommended or preferred by the FCC. Can you touch on that?
Certainly. As drafted, the department would give deference to the formulas that the FCC has developed for pole attachment rates. As I indicated, this would be used when parties weren't able to come to a negotiated agreement, but it would bring, in those instances, the pole attachment rate more in line with the FCC formulas, certainly.
Follow up?
And then also it's unclear to me how New Hampshire's rates, pole attachment rates, compare to other states. I mean, I've heard that they're higher, they're lower. Do you have any sense as to how our rates compare to Maine, Vermont, Massachusetts?
I don't have any of that information with me today. It's certainly information, if you're interested in, we could go back and collect and provide to you if you'd like.
Representative Kaplan has a question.
Thank you. Thank you, Mr. Chair, and thank you for coming in this morning. Just for a little bit more clarity on the formula, it does say that you will give deference to the FCC formula, but you may consider other formulas. So what other form, what type of other form would that be, from other state formulas, or how would they differ from the FCC? Thank you.
So that's a little bit of a chicken and the egg question. I think until we have a stakeholder session and hear input from the various stakeholders involved in the pole attachment process, I can't really point to another formula that might be considered. I'm sure we'll hear from other folks. Yes, I believe some of our electric utilities have a formula that they use in determining what the pole attachment rate is for pole attachers. So that may be a proposal that gets put forward and considered in conjunction with the current FCC pole attachment rate.
We can find out more about that later. Mr. Licata from Eversource will be testifying. Representative Munns.
Thank you, Mr. Chair. Just as a kind of another follow-up to my question about the rates and how they compare. Has there been any analysis done to indicate what, adopting a more FCC compliant formula would do to electric rates, cable rates? Presumably it would change how much the attachers pay, which ultimately is going to get passed through to consumers. Has any analysis like that been done?
This is just the very beginning process for this. So at this point, no. We haven't looked at what that would be. This formula would be for use in instances when a pole owner and a pole attacher can't voluntarily agree upon a pole attachment rate. So to the extent those agreements are in place now, they go forward. To the extent they can negotiate an agreed to rate, as they've done in the past, that would occur. This would be used when there's a dispute about what the pole attachment rate should be.
Okay, seeing no further questions, we want to thank folks from the department for being here. Now we'll get a perspective from the industry, and I'll call on Paul Phillips of the New Hampshire Telephone Association. And I think he'll be joined by Chris Rand of Granite State Communications, and they will give us their perspective on this legislation. Good morning, gentlemen. Thank you.
Good morning, Mr. Chairman, and thank you, members of the committee. My name is Paul Phillips. I'm an attorney with Primer, Piper, Eggleston, and Kramer. I live in Plymouth, New Hampshire. I practice law in Manchester, New Hampshire, and I represent the New Hampshire Telephone Association. I've been their regulatory counsel for approximately 20 years, including representing them in two pole attachment rulemakings before the PUC, one in 2008, which adopted the Chapter 1300 rules, and one in 2017, which amended those rules to acknowledge and accommodate the FCC pole attachment formula. We are here to oppose SB 595. I'm joined by Chris Rand, who is an owner and officer at Granite State Communications, and I'll let Chris start things off.
Good morning, Chris Rand, Granite State Communications. I'm the Vice President, and Granite State Communications is a broadband and voice provider. We provide fiber to the home and business services in 8 communities across southern New Hampshire, from Washington down to Sandown. I'm here on behalf of New Hampshire Telephone Association. NHTA members own poles or share ownership with electric companies. We feel that the FCC formula is already generous to attachers. In the case of Granite State Communications, the attachers are only paying a few dollars per year to attach to our poles. We understand broadband has become a very competitive service to provide, and we're concerned that this bill would allow the attachers to bring us in front of the FCC in an attempt merely to shift their cost of attaching onto our customers. For NHTA members, renting space to attachers is not a lucrative line of business. It often costs more than the revenue that's generated. And the NHTA members see this legislation as a reaction to a contract dispute between a single pole owner and a single attacher. We don't see any benefit to an expensive and protracted regulatory process. The agreements that were mentioned earlier are private agreements. They're voluntarily entered into between 2 parties. Any contract dispute can be resolved via the terms of that agreement or the existing regulatory processes as they are. And we don't see that it's necessary to pull in all the pole owners across the state of New Hampshire when it's a dispute between 2 parties. And that's it.
Thanks, Chris. The NHTA companies have not had occasion to come to the legislature for quite a few years because in 2012, as you know, the legislature enacted SB 48, which effectively deregulated telecommunications in most areas. One area that was not deregulated was pole attachments, and so that's why we find ourselves before you today. But NHTA's view of that is that the existing mechanism for resolving pole attachment agreements and pole attachment disputes is working well. And this legislation is effectively a form of re-regulation, which will create more regulatory headaches and problems for companies like the NHTA companies. The current system is that the PUC rules strongly favor private contracts. These are sophisticated parties. They engage in arm's length negotiations. They represent their interests well, and they reach agreements on the attachments. Where they can't reach an agreement or an existing agreement falls short, they can go to the PUC and they can present their facts, their evidence, and they can have a case-specific adjudication and assignment of rates from the PUC based on the facts of the parties that are before them. What this legislation does is turn that on its head. It starts out with a state mandated formula, one size fits all formula for all owners and attachers, and it effectively negates or nullifies those contracts because you'll know as you are entering into that contract that there's a state formula out there, and if your calculation shows that you're better off under the formula than you are under a contract, then you'll go straight to the PUC and say, please impose this formula. So it will injure and harm that arm's length negotiation process for those private contracts. It will unbalance that negotiation. And in our view, that's a waste of time and resources. We think the legislation creates a lot of open-ended questions. There are cases around the country where state-imposed poll rates have been found to be a constitutional violation of the Takings Clause. New Hampshire and New England have not gone that route yet, but at the same time, we've not had a state mandated formula for poll rates so far. So that would be one piece of litigation that we might see coming down the road. We think that the proper course for the House would be to send this bill to interim study. We think that it would be wise to explore some of the implications of the legislation and understand the real impacts before you take it up again. So thank you. We're happy to answer any questions.
Thank you. I have a question for you. I heard the department say earlier that this formula, once it's developed, would only be used in the case where two parties couldn't agree to a contract. It would be a kind of a fallback position. But if I understood your testimony correctly, you're saying that this formula would become the standard, would become the default that everyone would use. It would not be a fallback. Is that your
I
position?
think that's clearly the intent of the legislation. If you look at the existing PUC rules and the 6 factors that Ms. Noonan was referring to earlier in her testimony, one of those factors is the FCC formula. So when you have a dispute under a poll contract and you take it to the PUC is supposed to set rates for those two parties, and one of the factors they consider is the FCC's formula. So you have an opportunity to present your facts and your economic situation. And for small companies like NHTA, they may have higher costs, they may have different factors, but the FCC formula under the PUC's rules has become the driving force in those discussions. In SB 595, you start with the formula, right? The state develops the formula first, and then you have that hanging out there so that as you're entering into your private negotiations, if you're looking at this contract, what the rate that the state wants already is, and it's fairly guaranteed. If you take that dispute to the PUC at that point, they're going to adopt or they're going to impose that formula on your situation. So if it favors you, that's great. If it doesn't favor you, then you're kind of stuck.
So you're basically saying that the existence of the formula would preclude good faith negotiations between two parties to come up with a contract.
We think you would effectively hinder and hamper those negotiations, right? I mean, you've got a state formula that's been developed in a non-adjudicative proceeding. It's not based on, evidence and facts. It's based on, other factors. And it's going to be hanging out there as kind of the albatross.
You mentioned earlier that this legislation would create, quote, headaches and problems, quote, for you, the members of your association. Could you put some meat on that bone and tell me what kind of headaches and what kind of problems you're talking about?
Well, sure, yeah. We think there are a number of open questions. One is, what is the effective enforceability of existing poll contracts if this legislation passes? Because you really can't defend a poll contract that's going to have rates that are, in conflict or in contrast with this state formula. So how do you effectively enforce this contract, knowing that as you're going into the PUC, this formula is going to drive the discussion? So, you have contracts, you think they're valid, but are they enforceable? Is there going to be any meaningful process left for adjudicating these contractual disputes? The intention seems to be that the formula will streamline that process, but the simple fact of the matter is that if you don't have any facts to argue about as you go into an adjudication, what's the purpose of adjudicating? As you may know, and I think it was alluded to earlier, poll attachments under federal law fall primarily within the jurisdiction of the FCC, unless a state has certified to the FCC that it has an effective and fair regulatory scheme on the state level. And the PUC in January of 2008 certified to that fact to the FCC. The FCC rules require that there be a timely adjudication of disputes. And we believe that this throws the adjudication process, well, I won't say out the window, but into some question. And so we have some concerns about whether this statute would continue to comply with FCC standards and whether the 2008 certification would remain effective. So that's another issue that we have. So I'll stop there. We have a number of questions.
Okay. Representative McGee has a question.
Thank you, Mr. Chairman. He can tell when I'm chomping at the bit in a row of questions. Okay, so my question is as I'm listening to you speak, what is striking me is that you're here sort of advocating for companies who own poles that are not the utilities, not the monopoly utilities, right? So there's a market where poles are owned by different individuals, and this is it correct to assume that this might disadvantage those smaller pole owners with this burdensome regulation than it would for sort of the larger folks who, they're marketing this bill to us as providing predictability.
Well, our concern is for the smaller companies like Granite State, like Dunbarton Telephone, like Bretton Woods Telephone, that don't have substantial customer bases, and their poles are one of their main assets. And under the present system, if there's a dispute about the pole attachment rates, either the attacher or the owner can take that case to the PUC and have the merits of that case heard based on the facts and the circumstances of those parties. And that seems to be what is trying to be avoided with this legislation, is not to have case-specific, fact-specific resolutions of disputes. It seems to be a one-size-fits-all, one state, one rate type of solution. And that is going to burden smaller companies.
Thanks.
Representative Vice Chair Thomas has a question.
Thank you, Mr. Chair. Thank you for taking my question. And pardon if I don't fully understand this, but would this bill, is there any effect, either positive or negative, or maybe no effect on this bill in terms of how poles would be replaced, or the timing, or how fast they would be replaced if they had to be replaced or repaired? Would this bill hamper that process anyway, or have no relation to that?
Well, there is a relationship. I think we'd have to see what the formula is once it's developed by the DOE. We don't know, based on the statute, which factors are going to go into it. I mean, what we're hearing is that they want to bring it closer into alignment with the FCC formula, but the legislation doesn't say we're just adopting the FCC formula. They say there's going to be a number of other factors. They're going to look at other things that are not currently in the rules. So the purpose of a formula, at least from the FCC's perspective, is to take into account all of the costs that the pole owner bears in terms of deploying those poles and maintaining those poles, as well as the costs that the attacher brings to the situation when they attach their facilities to the poles. And all those cost factors are supposed to be put into a formula and generate a fair and equitable rate that everybody can agree to that reflects the appropriate apportionment of those costs. I don't see that language in the statute. I think there's an expression of intent about that, but we don't quite know what the formula is meant to be at the end of the day.
Follow up?
Thank you, and I'll ask the question differently. I think I understood your answer, but in terms of, as you might know, we've had issues in the state with poles not being removed that have been sitting there for maybe sometimes years, because of who owns the pole, how expensive to take it away, whatever. Would the current process we're under now be better in terms of getting those poles issues resolved, or would the new process speed up the removal and replacement of old poles?
Well, right. So there's nothing in the statute that speaks of the actual maintenance and replacement of poles. It seems evident on the face of the statute that the intent is to reduce the revenues, if you will, for the pole owners, which means that they will have less revenue than available for things like pole maintenance. I mean, I will just say I'm not suggesting that my clients are not going to maintain their poles. They do a great job. I don't believe they have the issues that you're describing, which may afflict some of the larger companies. But, you know, it is ultimately a cost versus revenue effect. And the idea here is to reduce revenues for the owners.
Representative Kennedy has a question.
Thank you, Mr. Chairman, and thanks for taking my question. You've explained pretty well how this might harm some small companies. Could you give a simple explanation of how this might lead to higher costs for ratepayers?
Well, sure. I mean, as Chris's testimony suggested, this is essentially a resolution of a contract dispute between an attacher and a pole owner. And the attacher didn't like the outcome of the adjudication, and so they're looking for a legislative fix to that. But the idea is that the attacher wants to pay less. Obviously, the owner is going to get less, and that's going to those revenues are going to be lost. These are pole owning utilities, right? They're either telephone companies or electric companies or both, and they are serving customers all across New Hampshire. And if they are not getting revenues from attachers, they're going to have to make up those revenues elsewhere. The NHTA companies, as I said, in 2008, stopped being rate regulated, so there's no longer, an immediate pass through to the ratepayers. So my clients will have to take account of those lost revenues and figure out what the best solution is. But if they were rate regulated, they might well just pass those lost revenues on to their ratepayers.
Follow up?
Yeah, so I see that as a matter of fairness, but could that lead to increase in charges by the companies that own the poles and a decrease in charges by the company that is supplying the service or whatever it is they're attaching?
If I understand your question, you're asking whether there might be some gaming of rates in play here between competing providers, and we think there may be some of that. I mean, I don't want to impugn anybody's motivations, but that at least in terms of the way this legislation came out of an adjudicative process at the PUC, we think there might be some of that going on. You want to speak to that, Chris?
No, I think you said it very well. There is-
Representative
there's
Floje
no-
has a question.
Thank you, Chair, and thank you for taking my question. Not following this through the Senate, one of my questions, I will go with this one. Since it can be adjudicated through the PCUC, what percent in the last couple of years have gone that route that caused this legislation to come before us?
Very, very few. I mean, it really is an aberrational case to have a poll rate adjudicated at the PUC. The system. I mean, this is the whole purpose of the PUC rule. If you read the existing rule, there's a very heavy emphasis on private contracts, and that's been in place for many, many years, and the system is working well. There are very few disputes that reach the PUC.
Representative Harrington has a question.
And thank you, Mr. Chairman. Thank you for taking my question. You had mentioned about cost shifting. So other than the costs that we are pretty familiar with, which would be property taxes paid on the poles, what costs are associated with your pole having somebody else's communication line on it?
You want to speak to that, Chris?
The poles themselves obviously have a life to them. And the cost of that is spread over many years. Essentially, the formula entertains what it is, what the costs, the inputs are to come up with that pole attachment rate. And if there's a process at the PUC, which in some cases may artificially reduce that attachment rate, then those costs would simply have to be pushed somewhere else.
Okay, follow up.
Follow up.
Yeah, let's forget about the PUC and all the government stuff. Let's just talk about your company. You have a pole out there. You run your, I assume, a telephone line on it. maybe there's an electric line on it, maybe there's a cable line on it, maybe there's a internet line on it. How are those other than your line?
Yep.
What costs do you incur by having those other attached to your pole?
The taxes and just the ongoing expenses, which may include ice and snow, pulling those lines down, routine maintenance, requiring the cost of replacement of the pole, et cetera.
Okay, one more question, but you don't replace in other words, if let's use this, regretfully, the last month where we've had a large number of poles come down all across the state. If you have your pole and it comes down, I'm just trying to assess the cost. So if it hits somebody else's line and that causes the pole to snap, then you're stuck with replacing the cost of the pole, regardless of why it came down.
That's correct. For Granite State Communications, most of the poles that we own, we share with Eversource. There are some cases where we have solely owned poles, and then where we rent space from other pole owners. But the vast majority of them are owned by, in our areas, half are owned by us, and the other half of the pole is owned by Eversource. We share that ownership.
So the more attachments, the more.
We bear the cost of replacing that pole.
Okay.
Yes.
Representative Harrington and other people would like to ask questions too. Representative Partial has a question.
Thank you, Chair, and thank you for being here today. In 2013, the Public Utilities Commission did devise a formula that is sometimes applied in these cases, I believe. Did that result in a closing down of negotiation in any way when, according to your scenario of how this could be detrimental to negotiation? Did that have any effect on it?
It's a great question, and I've only read the decisions. I've not been involved in any of those adjudications because the NHTA companies have not had occasion to have those disputes. But the way that the system works now is that if you're an aggrieved attacher or an aggrieved pole owner, you take the case to the PUC, and one of the factors they consider is this FCC formula. The FCC formula certainly drives the discussion, but the PUC is able within those case-specific adjudications to take account of other factors that are unique or specific to the individual parties. So the formula does weigh heavily in the discussions.
Follow up, please.
Follow up.
And it's your belief that a formula to replace the existing formula would not be as meldable as far as allowing those negotiations that we do want to have happen?
Right. No, I think my point was that, well, first of all, we don't know what the formula will be because it still needs to be defined, and the factors that are listed in the statute are different from those that are in the rule right now. But I think my overall point was that knowing that there's this formula out there that is blessed by the state, right? It's been blessed by the DOE and the PUC, and that they know that they're going to use it, faithfully in every dispute. Creates, it sways the discussion. It will. It tilts the balance, if you will, in those negotiations.
Representative Bernardi has a question.
Thank you, Mr. Chair. So, as I'm listening to this, it seems that the driver of your position comes from the belief that a formula is going to end up giving the companies less revenue than they currently have available to them, or put them in a worse position in any kind of negotiation. So do you have the ability to make the case in the discussions with the setting of the formula that's going to be adopted to present a position that will influence a formula that's going to take care of you from a cost perspective?
I mean, I expect we will take part in, if the legislation passes, we'll take part in that non-adjudicative proceeding. A non-adjudicative proceeding is different from an adjudication because it's not based on specific facts that apply to specific parties. It's based on larger policy questions and and the DOE in this case will take account of all the comments, but they're not strictly bound by evidentiary rules or evidentiary standards. They don't have to, adjudicate a particular dispute. So, I mean, we'll take part if that's the case, and we'll make our best pitch. I think our concern is that we only get the one shot. So if the DOE doesn't believe us on that day, we're stuck until the next non-adjudicative rulemaking.
Follow up?
Are there specific criteria that you think would be important for the DOE to examine and internalize into the eventual formula that would arise from this, that would put the companies in a position that then is acceptable to them?
I mean, I think that we haven't obviously discussed this, but I think the argument we would make is we'd like to see some differentiation in the eventual rule for smaller companies with different cost criteria. So we'd want to see some ability to distinguish smaller from larger and local from national and, all that stuff in terms of the impact of the rule.
Okay, members, I would like you to consider holding your further questions for future testifiers. We have 4 more people who would like to testify, additional perspectives we'd like
Thank you
to
very
gain
much.
here.
Thank you.
So thank you, gentlemen, for being here. I've heard it mentioned a couple of times now, effect on ratepayers. Well, if there is anybody in this room who can tell us more about the effect on ratepayers, other than our consumer advocate, I don't know who that would be. So I'd like to call next on our consumer advocate, the ratepayer watchdog, Donald Crease, to give us his perspective on this legislation.
Thank you, Chairman Vose, and good morning to you and to members of the committee. As you all know, I'm Donald Crease, the consumer advocate. My job by statute is to advocate on behalf of the state's residential utility customers. And my testifying today might be an example of fools rushing in where angels fear to tread, in that I am not an expert on pole attachment and the rules that are applicable thereto. So I don't have a lot to say about this bill. My recommendation to you is identical to the one you just heard from Mr. Phillips, which is to consign this bill to interim study. And here's why. And really, Representatives Kennedy and Munns have already made my case for me. The cost of maintaining a network of utility poles is a zero-sum game. The companies that own poles are going to recover their costs from somebody one way or another. So if the third-party companies that attach their facilities to a utility's poles don't cover the costs, or to the extent that they don't cover the costs incurred by the pole owner, then the pole owner is going to turn around and charge its regulated ratepayers. We're moving to an era in New Hampshire where utility poles are going to be owned by our electric distribution companies. And while I really love our electric distribution companies, none of them are charities. All of them are going to recover from their regulated captive customers whatever they do not recover from pole attachers. My understanding about this bill, first of all, it struck me that the proponents of the bill who have testified so far today don't seem to understand the bill and its implications, which to me suggests a good reason to for sending this to interim study so we can all think about it some more and make sure that we do the right thing vis-a-vis ratepayers, because we are, as ratepayers, the only wallet in the room. And the other point I would make is that it does indeed appear to me that what happened here is that there was a contentious pole attachment case that was pending before the PUC that the pole attacher did not like the results of, and the result is this bill that was presented to you. I unfortunately did not testify about this in the Senate. My practice these days is not to look for reasons to testify at the State House, but only to go and appear at hearings when asked to, and I just wasn't paying attention to pole attachments over in the other body. But I did hear about this bill from both sides, and I've come to my own independent judgment, which is I think this bill should be consigned to interim study. That's the extent of my testimony, and of course, I'd be happy to entertain friendly and non-friendly questions.
Okay, Representative Kennedy has a question.
Thank you, Mr. Chairman. Thanks for taking my question. I mean, right now, it seems like the FCC has the main body of rules. The PUC can make some adjustments, and there's a private negotiation. Is there anything wrong with that system?
No, this is an example, I think, of cooperative federalism at work. Back when I was general counsel of the PUC in 2008 or 7, the question came up like, do we continue to allow the FCC to do the regulating of pole attachments, or do we claw back some of the authority because the Federal Telecommunications Act allows states to do exactly what New Hampshire did, which is pass a statute saying, no, our commission is going to regulate that, but the FCC does have a role. It does establish that formula. It's entitled to some respect and deference. So I think that in terms of who is best equipped to regulate what the amount of money is that pole attachers get, it is best done on the state level, and that is in fact what we do. But the FCC does continue to play a role.
Follow up?
So is the answer no?
Is the answer, your question to me was, does the existing paradigm, is it okay? And I think it is okay. This bill would tweak it in a way whose effects, I think, are intended to be more costs to electric and other ratepayers of pole owners, less costs to the unregulated companies that also need to use poles. Representative Harrington asked before about, I think his questions had to do with what's the incremental cost if you add another wire to a utility pole? And the answer is nothing, essentially, or very little. But that doesn't mean that you should be able to attach your wires to poles for free. If you're a pole attacher and you're making money by using the network of poles in a particular territory, then you should pay your fair share of those costs. And if you don't pay your fair share of those costs, the people who are going to make up the difference are captive ratepayers. That's my ultimate point.
Representative Ploget has a question. Microphone, please.
Thank you, Chair. And Mr. Crease, thank you for taking my question. I'm going to ask you a question I was going to ask further because you mentioned a ratepayer. And being involved in similar contracts like this as a small business owner, I was going to ask them the questions of length of term and things like that. But going back to the ratepayer, I'm a small business. I have no choice to look for other poles. Those are the only ones in monopoly. I had to look for a long-term contract because I knew I was paying too much, but I needed to spread it out. And over the course, everything worked. But you brought up a point about the large distribution companies taking it over. They don't need to do what I did. They just pass it on. Is that correct?
I think that is correct, yes.
Representative Thomas has a question.
Thank you, Mr. Chair. And thank you for being here. You've mentioned now interim study, and the last group of people also mentioned that. What is it in this bill that is worth saving or investigating by going to interim study, and why not just kill it?
Well, I suppose I've been told that there are inconsistencies between the way the PUC decided the dispute over how to compensate or how much Eversource should have been allowed to pay for the poles it bought from Consolidated, which implicates a lot of the same issues, and the pole attachment dispute that the PUC resolved that was the subject of rehearing motions and a lot of protracted litigation. So what I don't understand, and what I think you might also not understand, is really what the best public policy is here around fair allocation of pole attachment costs. Utility poles are very important, and our network industries are very important, but we have to get the cost allocations right.
Okay, seeing no further questions from the consumer advocate, we want to thank you for being here.
Thank you for hearing my testimony.
Great to see you. Now we'll call on Mara Weston, who represents NECTA, to get her perspective. Good morning, Ms. Weston. And Ms. Geiger. I forgot you were going to be there too, Ms. Geiger. Sorry.
Good morning, Chairman Vose, members of the House Science and Technology and Energy Committee. For the record, my name is Maura Weston, and I'm here today on behalf of the New England Connectivity and Telecommunications Association. NECTA members in New Hampshire include BreezeLine, which is formerly Atlantic Broadband, Charter Communications, and Comcast. Together, our members service approximately 485,000 customers and offer their services to more than 695,000 locations in 185 communities. Joining me today is attorney Susan Geiger. As a former PUC commissioner and regulatory attorney, she's going to be here to help answer your questions. NECTA supports Senate Bill 595 as amended, and we thank DOE and other stakeholders for their efforts in helping to craft this legislation. We believe that this is an important clarification to existing statute. As you've heard, it directs the DOE to adopt a pole attachment rate formula using historical cost data, and it provides guidance to the DOE and PUC on resolving pole attachment disputes when and if they arise. This does not change reliance on pole attachment negotiations and agreements. And it also does not change the forum for disputes from the New Hampshire PUC to the FCC. Current law calls upon the DOE to develop a pole attachment formula. And additionally, as you've heard, the rules contain up to 6 factors, including a formula that the PUC should consider when determining whether a pole attachment rate is unjust and unreasonable in the event of a dispute. The process and these factors are vague, ambiguous, and amorphous. They were adopted in 2007, and they were applied and tested for the first time in 2023. The formula adopted pursuant to 595 as amended would be simpler and transparent, ensuring maximum clarity and predictability for all stakeholders. It is not one size fits all. It is not rate setting. It is the adoption of a formula that would consider many inputs, and Susan can speak to that. I want to mention that currently Eversource and other utilities use formulas very similar to the FCC formula that is currently the practice for many utilities. So this is not a drastic change for that group of utilities. As I mentioned, Senate Bill 595 as amended would create more predictability. It directs the agency to give deference to the longstanding, widely accepted, and judicially approved FCC formula while allowing them flexibility to determine what is right for New Hampshire. That formula, the FCC formula, is in place in a great majority of U.S. states, including Maine, Massachusetts, Vermont, and Connecticut. In fact, most New Hampshire pole owners and attachers already operate in states where an FCC-based formula is in place. New Hampshire currently is truly unique and an outlier relative to calculating pole attachment rates, again, in the event of a dispute. We have submitted written testimony, or I have testimony that I will submit, and there is more information in that regarding the practice in other states. So the advantages of a formula based on the FCC formula are numerous. It's well known and understood to parties. It has been found to be non-discriminatory and fully compensatory to pole owners and fair to attachers. It has been fully litigated under federal law. This type of certainty would actually reduce the likelihood of litigation which is expensive and is also a cost that is passed on to ratepayers. My understanding, to give you an example, is that in Massachusetts, where an FCC-based formula is in place, there has not been a dispute on rates since the 1990s. Importantly, this bill also calls upon the agency to develop an accelerated dispute resolution process. In December of 2023, in recognizing that lengthy and expensive disputes were delaying investment in broadband deployment, the FCC adopted an accelerated dispute resolution process for the 30 states that are not certified and who defer pole regulation to the FCC. For New Hampshire, which is certified to the FCC that it will regulate disputes, an accelerated dispute resolution process should be paramount. Quick resolution of disputes in the event of a dispute provides more predictability, certainty, and frankly, it discourages unnecessary disputes. Again, it's important to note that most New Hampshire pole operators and attachers operate in states where these processes are already law. Such an expedited process is key when one considers that in many cases, poles are owned by the competitors to the entities which are seeking to attach to them. Utility poles are among the last remaining monopoly assets in an increasingly deregulated industry. There is no economically viable alternative to attaching to utility poles for wired networks, and there should be no anti-competitive incentive to create delay in deployment. The avoidance of disputes, expeditious resolution of disputes relative to pole attachment rates is significant in that, again, money and time is not spent on litigation when rapid deployment is key. Lastly, Senate Bill 595 clarifies that the agency has the authority to implement the statute and require pole owners to maintain the necessary records to justify their pole attachment rates and make that information available to the attachers to verify the accuracy of rates. Transparency in record keeping and in the process is of utmost importance. So in conclusion, just to summarize, we believe that this clarifies the law. It absolutely aligns New Hampshire with other states. It creates predictability in calculating pole attachment rates, creates processes for dispute avoidance and expeditious resolution. It improves transparency, and truly it helps align resources with priorities around deployment of infrastructure. So we ask that you recommend Senate Bill 595 ought to pass as amended by the Senate. And I'd like to turn to Susan to see if she has comments to add, and we're happy to take your questions. Thank you.
Good morning. I don't have anything in particular to add to what Maura has stated, but I would be happy to take any questions that the committee may have.
So I have a question for you. Ms. Weston mentioned that an accelerated dispute resolution process is needed. I read through the text of this bill and I don't see any mention of that. Is it somewhere in here that I just don't see, or can you explain
Yes.
that to me?
That's right. I think that in what would become the new section 10, see, I think it's 10A6, that would give the Department of Energy, the commission would need to conduct a formal rulemaking to incorporate the formula that the Department of Energy develops, along with rules for accelerated dispute resolution. That's on the
Line 24, correct?
yes.
Okay, thank you. Further questions for Ms. Geiser, Representative Munns?
Thank you, Mr. Chair, and thank you for coming in and meeting with us this morning. As an organization that does cover all of New England, I'm wondering if you can answer the question I had asked earlier about what the impact or how rates in New Hampshire currently compare to Maine, Vermont, Massachusetts, Connecticut, and what would the impact of this be on those rates?
Yes, I can give you one data point. In New Hampshire, Consolidated Communications, and this was back in as of 2022. This is the data I have. Consolidated in New Hampshire charges for a solely owned pole that it owns by itself. It charges each attacher, or I'll say it charges some NECTA members as attachers $11.67 per year per attachment. So for every attachment on every single pole that Consolidated owned in 2022, each of those attachments was assessed the charge of $11.67 on a solely owned pole. In Maine, the comparable figure or charge was $3.56. So, and on a jointly owned pole, on a pole that Consolidated owned with another entity, like Eversource, for example, Consolidated charged $6.84 in New Hampshire per attachment, per pole, annually, and in Maine, Consolidated charged $1.78.
Thank you.
Okay, additional questions. Representative Lewicki has one.
Chairman, thank you for taking my question. Are there businesses in New Hampshire that have been unable to operate either temporarily or in the longer term because they were not able to attach to poles, or was this strictly a financial issue?
Thank you for the question. I'll phrase it this way. To the extent that a pole attacher is trying to gain access to poles to serve new customers and is unable to negotiate a rate with the pole owner, then deployment of the attacher's assets will be delayed. We think this bill will eliminate that delay in broadband deployment by allowing a formulaic approach to the issue of what rates should be charged to that attacher, and that can expedite deployment.
Representative Thomas has a question.
Thank you, Mr. Chair. And this question may have been asked. I was late to the hearing, so if it has been, I apologize. How many pole disputes occur on a yearly basis?
I'm only aware in the last, say, 12 years at the PUC, I'm aware of 2 cases that actually went to adjudication. I'm not familiar with the number of disputes that occur that are resolved informally. I'm just aware of 2 cases that were actually adjudicated at the PUC. There may have been more.
Representative Kaplan has a question.
Thank you, Mr. Chair, and thank you for coming in this morning to talk to us. I was just talking to my wife this morning, and she mentioned that we have 2 internet providers in our town. And if I understand you correctly, this bill would increase the number of internet providers in rural areas. Would that be correct to draw that conclusion?
I don't see that this bill actually goes to that issue, but I think to the extent that the bill provides certainty and an objectively reasonable standard for setting pole attachment rates, I think it will be perhaps more efficient and expeditious for a potential attacher to reach agreement with the pole owner so that the attacher's broadband facilities could be deployed more expeditiously than currently.
Representative, follow-up, go ahead.
So this bill would possibly benefit operators that are already in the state. It would not bring in, are you saying, and to your knowledge, there are no waiting, there's not a backlog of people waiting to get into the state to do business on those poles?
I don't have the answer to that question.
Representative Harrington has a question.
Thank you, Mr. Chairman. Thank you for taking my question. We had a lot of discussion with the previous speakers on what the effect with this would be. So it appears and correct me if I'm wrong on this, but it appears that there would be really no negotiation on either the attacher or the pole owner's part. They would simply go to the formula and figure out, okay, I'm going to get charged, I can charge you X amount, that's what I'm going to charge you. Or on the attacher's point of view, saying, you can only charge me X amount, that's what I'm going to pay for you. And why would anyone negotiate a different rate if it was already know that the fallback was based on statute? I mean, that's the one, it's going to be effectively become the rate, isn't it?
So I'll start, and then maybe Susan can clean up to help answer the question. The FCC formula has been, or I should say, 30 or so states cede authority to the FCC and the FCC formula. It is well known. It has been adjudicated. It is supported by a body of law that is compensatory and just for both parties. And my sense is pole attachment negotiations occur regularly. There are voluntary agreements, knowing that this body of law exists. I don't see that this bill changes the voluntary negotiations between the parties whatsoever. These factors are well known. What we're talking about is what happens in the event of a dispute. And the 6-factor analysis under our regulations are vague and amorphous and create, I think, challenges and may lead to more disputes rather than fewer disputes. That's my general sense. Susan, do you?
I'll just add one quick thing, Representative Harrington. The pole attachers and the pole owners negotiate these voluntary agreements. Rates are just one element of those agreements. There are other terms and conditions for access that are contained in those agreements. So I don't think it's necessarily a given that a rate that is produced by this formula is automatically going to be inserted into the contract. There may be some give and take in that negotiation process whereby the pole attacher is willing to pay a higher rate for more favorable terms and conditions that are not financial.
All right, thank you.
Representative Munns has the last question for these two.
Thank you, Mr. Chair. Yeah, I just want to follow up on that exchange with Representative Harrington. So if I heard what you said correctly, 595 would not impose a specific rate, that it would only be a rate that would go into effect if the parties couldn't negotiate. So they would still be negotiating?
That's correct.
Okay, thank you.
I would just like to add one quick thing to that. It is my understanding that this is not one size fits all. When you look at the formula, it really comes down to inputs. And one set of inputs for one pole owner could look very different than the inputs for another pole owner. So this is not one size fits all.
But I would add, any formula that is adopted, and if it's based on the FCC formulas, must be fully compensatory to the pole owner regarding the costs associated with that attachment. So I think Representative Harrington may have asked this question earlier about the utility's ability or the pole owner's ability to recover its cost. The FCC and the courts have held that the FCC's formulas are fully compensatory and they're just and reasonable. And that's what rate making is all about, is to produce a just and reasonable rate.
Okay, you've helped us a lot to understand the issues here, so I want to thank you both for coming to talk to us this morning.
Thank you.
Next, we'll hear from one of the largest pole owners in the state, Eversource. Michael Licata will give us his perspective on this legislation. Good morning and welcome.
Good morning. Michael Licata, representing Eversource, and as the chair pointed out, we own either in whole or in part 480,000 utility poles throughout our service territory in New Hampshire, and we are in support of the legislation before you today. The reason that we support is because we do believe that there is value in the Department of Energy setting a uniform formula rate that would be used in the case of disputes by the Public Utilities Commission. We think that that will provide a level of consistency and transparency that would benefit both pole owners as well as attachers and ultimately customers of both telecommunication services and our customers, our electric ratepayer customers. As I think was mentioned by Representative Partial, in 2013, the Public Utilities Commission did in fact approve a settlement between Eversource and several telecommunications providers, which set the formula rate that Eversource uses today. So our rate has actually been set, our formula has actually been set by PUC order, which I think is a little bit unusual compared to the other electric distribution utilities. And so that is a bit of a blended rate between the FCC telecommunications and FCC cable rates. And that is the formula that we apply today. And with that, I'll just say that I appreciate the bill's sponsor and other stakeholders' willingness to work with us in the Senate to address concerns that we had raised originally with the bill. And we are in support of the legislation before you today.
Okay, thank you. Representative Munns has a question.
Thank you, Mr. Chair. Thank you, Mr. Licata, for being here. We heard just in previous testimony that in Maine, at least, the rates for the pole attachment rates are lower than they currently are in New Hampshire. So, assuming that that is the case, that would happen in New Hampshire as well, you would suffer a pretty significant revenue loss on your 480,000 poles. How would you make that up?
Yeah, I think there's an assumption in the question, and I think there's been assumptions made during the hearing today that the DOE is going to make a finding of a substantially different formula than we have in place today, or something lower than we have today. As Attorney Geiger had said, the FCC formula is designed to make pole owners whole, but also there are other factors unique to New Hampshire potentially that the Department of Energy and the Public Utilities Commission would take into account when either setting the rate or mediating a dispute. So, it really depends on the rate that the Department of Energy would set and the resolution of a dispute that the Public Utilities Commission would mediate between pole owners and pole attachers on whether there would be a change in revenue.
Follow up. The rate that was negotiated or adjudicated by the PUC, what is that rate?
I was worried you were going to ask me that, but I did come prepared. So it is 0.44 times the space factor times the net cost of the bare pole squared times the carrying charge rate squared. And the space factor formula, which I can go into if you'd like, is also in the order, and that's basically the usable space of the pole height, the number of attachers, and the usable space.
Did you need to follow up on that?
So needless to say, it's a fairly technical formula.
That reminds me of the joke about the accountant when someone asked him if they could explain something and the accountant gave a very precise answer and the person said, well, you must be an accountant because it, doesn't help me at all.
I can promise you I'm not an accountant.
Okay, thank you.
All right, further questions for Mr. Licata. Representative Kaplan.
Thank you, Mr. Chair, and thank you, Mr. Licata. I'm going to try my luck with you and ask the same question. In your opinion, do you think this bill would increase the number of businesses operating in the state in terms of internet providers and cable providers? Like that?
I would say potentially. In the PUC order back in 2013, the commission, in its findings, noted that by setting the formula rate that they did, their hope was that it would increase the amount of telecommunications infrastructure in the state while balancing, obviously, the interest of customers and shareholders. So having a standardized formula, does that make the state more attractive to a broadband provider? I mean, you'd have to ask them, but I think that was part of the commission's analysis when approving our formula rate.
Representative Kennedy has a question.
Yeah, the last speaker said that the bill would increase the standing of the FCC rules. So I'm a little confused. Are we ignoring those rules now?
So I will say no. In the case of Eversource's settlement formula, which was adopted in 2013, they are quite consistent with different components of FCC formula rates. So there's a telecommunication rate and there's a cable rate. Please don't ask me why they're differentiated. Perhaps Ms. Geiger, Attorney Geiger could explain that. But it is, that does form the basis. And I would also note, there has been mention of sort of the 6-factor test that the commission is required to use when adjudicating disputes, and the FCC formula rate is one of those factors in that.
Representative Ploget has a question.
Thank you, Chair. Thank you, Mr. Licata. I'm still hung up on the need of this. Going just to mention Ms. Weston's comment. She said there was a legislation. My notes are not as good as Representative Corman's, please. That was put in 2007. I don't expect you to know this. I'm leading up to the question.
Okay.
But it hasn't been used to 2023. Then there was another disputes, if I heard right, goes back to 1990. I'll check with Representative Corbin of all my errors. But Eversource being a major player, my question is, can you share some of the disputes you had that needed to go to the PUC in the last few years? Thank you.
Yeah, there has been made reference to a recent dispute that was not a dispute that involved Eversource, is what I will say. We did have the settlement that I referenced. That was a complaint that was filed back by telecommunications providers back in 2012, and was, again, the end result of that is we were able to come to a settlement, file that settlement agreement with the PUC. That was approved, and that has been the formula that we have used. I don't want to sort of overstep. I'll defer to others in the telecommunication space who might speak to the specifics of the most recent dispute and that I think moved things along. And the legislation that you referenced, I think, was that 6-factor test that the commission is required to use when determining whether a formula rate is fair and in the public interest.
Follow up.
Real quick. Thank you. You did answer my question.
Thank you.
Okay, we need to move on here. We've got one more speaker. Representative Thomas, may you have a quick question?
Yes, I do. Thank you for being here. Was Eversource unhappy with the poll dispute process prior to the case that initiated this bill?
I think the answer to that is no.
Okay, let's move on and give the last word to, and I'm going to apologize for getting this name wrong, Meg Glonier. And I'm not sure who Meg represents, but she'll tell us.
Hi, good morning.
What is your last name, Meg?
Glander. Glander? G-L-A-N-D-E-R.
Glender? Oh, okay.
Yeah.
All right, thank you.
Yep. Good morning, Chairman and members of the committee. My name is Meg Glander, and I represent Crown Castle, for the record. We are the nation's largest provider of shared telecommunications infrastructure. Our work is crucial in providing connectivity to anchor institutions across New England, including to schools, state and local governments, hospitals, public safety, businesses, and major wireless carriers and cable companies. In New Hampshire alone, we represent over 100 government, school, and public safety customers and have 500 miles of route fiber, facilitating vital communications across the state on which every sector, individual, and community relies. As a neutral host provider collaborating across various sectors here in the state, Crown Castle is uniquely positioned to discuss today's topic, an essential component of infrastructure that's often overlooked until it becomes a bottleneck in our shared goal of closing the digital divide and ensuring fast, reliable connectivity, utility poles. These poles are vital as they provide a prevalent and widely available foundation on which to deploy the wireline and wireless facilities necessary to deliver the connectivity that Granite State residents require and deserve. Without timely access to well-maintained utility poles at reasonable and transparent rates, terms, and conditions, providing this connectivity becomes a serious challenge, which is why we support Senate Bill 595 as amended. This legislation represents a crucial step towards resolving significant inefficiencies in New Hampshire's pole attachment system currently, aiming to replace the current 2007 vague multi-factor rate test with a clear formula-based rate system to streamline processes, increasing transparency, and reducing unnecessary delays. This formula will leverage historical cost data, ensuring rates are fair, transparent, and consistent with practices in neighboring states like Maine and Vermont, as well as in line with the pole attachment formula set by the Federal Communications Commission. This law, of course, would be proactive to new disputes. I'd like to highlight we were not a party to that dispute everybody keeps talking about with the Public Utility Commission. In addition, an accelerated dispute resolution process, which is in line with what the FCC recently adopted, given all of the funding for broadband federally, would be something we strongly support. Currently, resolving disputes can take up to 180 days in this state. In the digital age, where connectivity is increasingly synonymous with opportunity, safety, and access to vital services, these delays are unacceptable. This bill will significantly reduce timelines, ensuring resolutions and facilitating faster broadband deployment, which becomes increasingly important as we look at the historic moment we're in. With $318 million from the federal government allocated to New Hampshire for broadband expansion through ARPA and the BEAD programs, timely and fair access to utility poles has become even more critical. While these poles might seem mundane, they're the backbone of our efforts to connect every corner of the state in a cost-effective way. Delays in accessing poles can also jeopardize not only the timely use of federal funds, but also our broader goals of connectivity and economic growth. In practical terms, imagine a scenario where a deployment is stalled because the pole owner and the broadband provider cannot agree on pole attachment rates or disputes drag on for months. If a pole owner is slow rolling negotiating a pole attachment agreement or granting access, that's where accelerated dispute resolution can really save projects. Otherwise, these delays could mean not only missing out on federal deadlines, but also delaying crucial connectivity for schools that need internet for learning, for hospitals that rely on data for patient care, and for businesses that need broadband to compete in the global marketplace. In addition, as a company that attaches wireless facilities to poles, we want to highlight that the vast majority of 911 calls are made via a wireless device. Unserved and underserved areas pose a significant risk in situations where timely arrival by first responders could quite literally mean the difference between life and death. The last thing we need in upgrading this kind of infrastructure are unnecessary delays caused by unpredictable pole attachment disputes. In conclusion, we urge the committee to support Senate Bill 595, ensuring that New Hampshire doesn't miss out on an unprecedented opportunity to enhance its communications infrastructure. And I'm happy to take any questions.
Thank you. Do you have written testimony to submit by any chance?
I could send it to you. I don't have it on me, though.
Okay, thank you. I appreciate that. Questions? Representative Harrington has one.
Thank you, Chairman, and thank you for taking my question. We could talk generally about attachments here, but that can involve more than just putting up a new wire on a telephone pole. What I'm referring to, do you think this bill addresses the issue of all right, there's a telephone pole, it's got an electric wire on it, it's got 2 communication wires on it, and now 2 more companies want to put things on there, and it requires movement of the existing ones. Probably not the electric one, because that's going to always be on top, but the other 2. So does this bill cover the cost associated with, I've already paid you, my wire's up there, now you want me to move it so you can put another wire up there?
Yeah, great question. I was talking to my team before about this. So when we put a node, we do an engineering analysis for a kind of node we would attach to a pole. So what would happen in that scenario is we still, if it was on us, on our attachment, we would still have to bear the cost of replacing the pole through our normal negotiation process. So that's irrespective kind of this, what we're talking about here.
What I'm, follow up?
Go ahead.
Yeah, what I'm referring to here is that the pole's there, it's existing.
Right.
Now a new company comes in and says, I want to attach to the pole, and they make an agreement with the owner of the pole. Does that include the cost of another company that's already attached to the pole having to move their wire because it physically needs to be spaced out more because you're adding 1 or 2 more wires to the pole? So is this bill going to cover that addition, because someone's going to have to pay for that? If company A has to move their wire because company B wants to attach, company A wants to get paid for doing it. Does this bill address that issue?
Yeah, we're currently not seeing problems with that in this state. The One Touch Make Ready process, that's kind of separate from this discussion, but we would have the normal negotiation process when we're going back and forth with the pole owner. And this would just come into play to have a predictable process. So it's like you're not driving your car without a GPS, so you know what the formula is when you talk to the company beforehand to prevent disputes.
Representative Munns.
Thank you, Mr. Chair, and thank you for coming in. You spoke quite a bit about the importance of an accelerated dispute resolution mechanism, and some other speakers spoke about that as well. Do you feel that the bill includes enough direction on that? I mean, right now it's mentioned, in one place as a accelerated dispute resolution mechanism. Do you think that the legislature needs to be a little bit more specific in terms of what that should include?
I think is currently written with the process that will be undertaken after this bill is hopefully passed with the Department of Energy, that all stakeholders will get to weigh in and really come up with what's best for the stakeholders of New Hampshire, whether it's the pole owners or the broadband providers. So I think is currently written, yes, it's enough.
Follow up. But what if the department comes back and says, yeah, we'll resolve issues within 180 days. I mean, that doesn't sound expedited, does it?
No, and I don't think that's the intent here. It's to resolve disputes within 30, 60, 90 days.
Representative Kennedy.
Thank you, Mr. Chairman. Thanks for taking my question. Representative Harrington was asking if the bill would address a very specific issue. But, when I read this, there's nothing specific in this bill. It says that a formula shall be developed. So how could you even answer a question like that?
Well, this bill, again, will take all stakeholders in the Department of Energy to be able to come up with a rate based on historical cost data. Yeah, I mean, I understand what you're saying, but this will, instead of a vague 6-part multi-factor test where you really can't predict things, would put a formula-based approach. It's clear and transparent.
Okay. Seeing no further questions, I want to thank you for being here and testifying to us this morning. And that will conclude our public hearing on Senate Bill 595 FN. And since we are significantly behind schedule here, I'm going to go directly into Senate Bill 603 and ask Grant Bossy from Senator Bradley's office to introduce this legislation to us. Thank you. Good morning, Mr. Bossy.
Good morning, Mr. Chairman, members of the committee. Thank you very much. My name is Grant Bossy, Deputy Chief of Staff for the New Hampshire Senate, and I'm here to introduce Senate Bill 603 on behalf of Senator Jeb Bradley, the bill's prime sponsor. What is uniquely New Hampshire? We lost the old man in the mountains nearly 21 years ago. Our first in the nation primary is under attack. Even Daniel Webster moved to Massachusetts to run for the Senate. But we still have three numbers that are unique to the Granite State. 603. In use since 1947 for Granite Staters, 603 is more than an area code. It's an identity. We have songs and bumper stickers and political slogans and craft beers and t-shirts. 603 is New Hampshire, and New Hampshire is 603. The growth of mobile devices has put a strain on the 603 area code, which of course can never accommodate more than 10 million unique phone numbers at a time. If we want to forestall the need for a second area code in New Hampshire, perhaps as soon as 2027, we need to find a way to reassign dormant and unused numbers to new phone lines. Governor Sununu last year signed an executive order to extend the life of the 603 area code, but changes in statute are also needed. Senate Bill 603 would empower the New Hampshire Department of Energy and the Public Utilities Commission to adopt conservation measures to the greatest extent allowed by federal law, such as reclaiming defunct and abandoned numbers. It would require service providers of Voice over Internet Protocols, or VoIP, to register with the Department of Energy when requesting numbering services. I would defer technical questions to the Department of Energy, but if you have questions for Senator Bradley, I'll make sure to get you an answer. Thank you for your consideration and hopefully support of Senate Bill 603.
Okay, thank you. Representative Nodder does have a question for you.
Thank you. It's good to see you, Grant. So I'm a little bit confused because people get a new cell phone and they often have somebody else's number, an old number. So isn't that already done?
I think the department can already speak to why numbers might be dormant and not available for reissue. And that makes one less number that we have in the 603 area code before, for instance, Massachusetts several years ago had to add 508.
Okay, no follow-up required. Representative Kaplan would like to ask a question.
Thank you, Mr. Chair, and thanks for coming in. I have a question about the utility of this bill in terms of the amount of time that it saves us. At some point, there will be a need for another area code. Do you have an idea of what the time frame would be for that if this bill were to pass?
I don't. I think if New Hampshire's population keeps rising and we keep using phones, we're not, replaced with some sort of Wi-Fi implant in our heads, we're probably going to need a second area code at some point. This would move that date down the line. Well, right now, I think without the executive order last year, without this bill, the department estimated we'd run out of numbers in 2027. That's just 3 years away. So this would push it down the line. I'm not sure how much. Hopefully the department can tell you how much more life in the area code we can get out of this.
Okay, seeing no further questions, I want to thank you and Senator Bradley for submitting this legislation. And we'll next hear from Chris Rand from the Granite State Communications. We heard from Chris earlier and like to get his perspective on this legislation as well. Welcome back.
Thank you, Mr. Chairman. I'm again representing New Hampshire Telephone Association. Few very brief comments for the committee this morning. The rural carriers in the New Hampshire Telephone Association have not been the numbering resource problem in the past because we just don't hold that many numbers. The challenges inherent in moving, for our members, in moving to thousands block pooling would be high, and the reward would be fairly low, again, because we hold very few blocks of numbers. It's not even clear that all of the New Hampshire Telephone Association members have the technology to implement thousands block pooling. We are in favor of the amendment, which simply would clarify that the thousands block pooling is not a mandatory process, it's a voluntary process. And that concludes my comments.
Thank you. Could you clarify what amendment you're referring to? Are you referring to the amended version of the bill as it came over from the Senate?
I believe so, yes. It inserts the words that all service providers that have chosen to participate in thousands block pooling.
Do you have a line number where that language might appear?
I have it. It shows in section 2. I don't have the full text of it here. So it would be around in the version I have, around line 19.
So it currently says, starting on line 18, ensuring that all service providers are in compliance with the FCC's regulations on thousands block number pooling and ordering rate center consolidation that it determines necessary after review and investigation. So you're,
And the amendment we requested in that section was that all service providers that have chosen to participate in thousands block pooling are in compliance.
oh, okay. All right, I'll have to double check my email to see what we've received on that, but I didn't recall that, what exactly the language you wanted was. It wasn't clear on whether it was already in the amended version from the Senate or whether it was something you were asking us to do. But I understand now, so thank you. So Representative Munns has a question.
Thank you, Mr. Chair. I got two just technical questions. What is thousands block number pooling, and what are rate center consolidations?
So thousands block pooling numbers are handed out on an NPA NXX basis where there are 10,000 numbers in that block. And then thousands block pooling is breaking that group of 10,000 numbers into 10 1,000 block pools of numbers. And then those are distributed amongst the different carriers in an area such as Concord, Manchester, Nashua, more urban areas where there is competition. So they're allocated on that basis rather than these large blocks.
And then what is a rate center consolidation?
So that would be where there are multiple blocks spread over a rate center, and they're not used as efficiently as could be. And that process of thousands block pooling is implemented to reduce the numbers that are allocated to a specific carrier in that rate center, and the remaining thousands blocks are allocated amongst the competitors that may be operating in that area.
So the basic problem here is that there are numbers that are no longer being used that need to be recaptured so that they can be used in the future?
Correct, yes. Yep.
Do you know
the
anything?
areas, sorry, go ahead.
Pardon me for interrupting. Do you know of any other states that have done this kind of phone number conservation successfully?
I believe it's in place all over the country, yes. Our position in coming here today was simply to clarify that we don't have the NHTA members operate in very rural areas, and we don't have the ability to implement some of these steps. So we just want to clarify that that is a voluntary, not a mandatory process. As written, we could envision a time down the road where a mandatory implementation of this may result in the entire block of numbers from a rural carrier being taken back. So it's simply cleaning up the language.
Okay, great. Thank you. Further questions? Representative Lewicki has one.
Thank you, Mr. Chairman. Thank you for taking my question. In a block, are the numbers consecutive, or can the block be a bunch of recycled numbers?
In a block of 1,000, they are, I believe that they're consecutive. I'm not as familiar with that because we don't participate in it, but they're sequential. Yes. Yep. And I believe each carrier is given 1,000 numbers at a time.
Follow up?
Follow up.
So there's no form of what in computers we call garbage collection, where the computer would find unused files, and in this case, find unused phone number that hasn't been assigned, and recycle them?
That's a very good question, and I'm not because we haven't been involved in thousands block pooling, we've asked the same question because there is porting where a customer of a landline company may port their number to a wireless company. And we've always asked that question is when somebody takes that and associates it with their wireless service and then disconnects that service, how does that number make its way back to the original carrier? And we're just not familiar enough. It's not as widespread as an issue for us.
Okay, thanks for giving us your perspective. Now let's hear from Karen Susi, who's going to represent the CTIA. And I don't remember what that stands for, but I'm sure she'll tell us.
Oh, goodness. Good morning, Mr. Chair, members of the committee. My name is Karen Susi. I work at Sheehan Finney Capital Group, and I'm here representing CTIA. We'll just call it the Wireless Association. So your T-Mobile's, AT&T, Verizon, U.S. Cellular. Sorry, I spoke away from the microphone. And we are in opposition to the bill. We definitely appreciate the meaning of the 603 area code, the brand, the identity that it brings to residents of the state of New Hampshire. I think what we need to consider, though, is how it's being done. And it's being done through a fee or a new tax to the carriers in order to implement, to bring it to fruition. And I think that's something that we definitely need to consider, certainly, especially when there's already $30 million each year brought in from the communication services tax that's put into the general fund. So we certainly don't have a clear number of what the fee or tax would be that causes us angst. We're not sure if it's a one-time assessment. We're not sure if it's something that will continue on. Can they keep coming at us when there are other issues that they need to investigate or establish? So again, we do understand, certainly I'm a Granite Stater, been here my whole life. My grandparents, my grandparents have been here, I understand. But again, we need to think about how we're doing this, and possibly, I would suggest, fund this alternative funding source and use it.
Okay, questions for Ms. Susi, Representative Corman.
Thank you, Mr. Chairman, and thank you for taking my question. I just want to make sure I understand your point here. So are you saying that the carriers will have to spend money actually implementing this procedure, and therefore that would get passed on to their customers?
So it's my understanding that the department is suggesting that there be this fee or tax to essentially hire a consultant to investigate how to implement this. We haven't been given a specific number. It could vary. We're not sure if it's going to be equitable or not to all carriers. And of course, I'm certainly sure there is the possibility that that could be a pass-through to customers.
So your assessment here is that the state is already collecting $30 million worth of communication tax from your members, which gets passed along to ratepayers. And then this is another cost that would get passed along to ratepayers, correct? Because the fiscal note says that such costs would be paid through a special utility assessment on all providers of telecommunication services. So you're seeing this as just an increase in taxes that are going to be paid by ratepayers, correct?
Yes, that's correct.
Thank you. Representative Notter.
I think you just already answered my question, so thank you.
Oh, okay, thank you. Representative Harrington.
Thank you, Mr. Chairman. Thank you for taking my question. Let's go way back in time. I remember this issue came up when I was on the commission, and I believe it was like 15 years ago or something, when it was, Save the 603 was the calling card for this movement. And I don't even remember what we did, but I think back then you had to get blocks of 10,000 was the minimum amount of numbers you can buy. And that was changed. So at least for, if I'm correct in my memory, about 15 years, we've been able to keep all telephone numbers in New Hampshire as 603. What what isn't working now that we can continue to do that we need a new program and a new assessment?
You know, I did look briefly back at that, and I think there was an effort in 2000 and possibly 2010 or 11 to do something to conserve the area code. The only thing I could figure out was that they did not use an assessment or a tax or fee to do so. You have more experience with that than I do, unfortunately.
All right, thank you. I don't remember a tax or fee being associated with either, but I could be wrong. Thank you.
Additional questions for Ms. Susi? Representative Bernardi.
Thank you, Mr. Chair. So looking at the fiscal note, it talks about $100,000 to $300,000 cost in the fiscal year 25 and 26 period. So it looks like a one-time cost. But if this approach has been used in multiple other states already, why cannot we just pick up what's been learned there and not have to pay this? It doesn't make any sense. Do you understand why we need this costing?
I do not understand why we need this. I think that's a question for the department. Again, if there's a cost that needs to be associated with doing this, I would strongly urge people to look to that communication services tax, which is already being taken in, wouldn't require the duplicative efforts of the department to seek out additional funding.
Thank you.
Additional questions for Ms. Susi? Seeing none, and hers being the last pink card I have on this, to testify on this bill, I would like to ask the department if they would be willing to come up and answer a couple of questions for us. Thank you for volunteering to do that. I appreciate it.
Yes, and apologies, I did fill out a pink card. It perhaps got lost along the way. So my apologies for that. But we're happy to be here, answer your
I
questions.
lost it somewhere.
And provide some information.
It was the same bill was referenced both times. That's why we had 2 testimonies for 595 and none for this.
Oh, okay. So I
An
guess you
early
forgot,
morning
you wrote the
error.
wrong bill number on the
An
card.
early
Okay.
morning error on my part. My
Okay.
apologies.
You're forgiven.
Well, good morning. We're happy to be here and talk about Senate Bill 603. I think you all heard about how 603 is an iconic New Hampshire symbol. As New Hampshire residents, we're all familiar with the branding and the importance of our 603 area code on our local economy. We are one of a handful of single area code states remaining in the country. Our neighbors in Maine are also a single area code state. And while we've been very successful with past efforts that you heard Representative Harrington talk about, in 2000, when we implemented 1,000 block pooling, and in 2011, we find ourselves being notified by NAMPA, which is the North American Numbering Plan Administrator, who oversees the administration and the numbering resources for the country, that our area code will exhaust in the second quarter of 2027. Looking to our neighbors in Maine, they were in a similar position in 2021. They had a projection of area code exhaust in 2024, and they undertook a number of steps that we've looked at. We've incorporated many of those same steps, and they were able to push their area code exhaust out 10 years to 2034. Whether we'd have the same success or not, we don't know. Our demographics and economic makeup are a little bit different, but we're very optimistic that we can push out with efforts the life of the 603 area code for some time to come. Perhaps enough time for the federal government to determine how to number across the whole country as these numbers, it's a finite resource, they'll dwindle. And a new numbering plan for the whole country will come into place some point down the road. 20-ish years, 25 years is the projection. So we'd like to keep our single area code for as long as we can and be a part of the robust New Hampshire economy that comes from that. There were some questions about 1,000 block pooling and what rate center consolidation was that Mr. Rand addressed. I just wanted to be clear that the North American Numbering Plan Administrator, or NAMPA, holds the numbers for all states and assigns blocks of numbers, that's the 1,000 block, or a code, which is a 10,000 pool of numbers, out to providers. Since the early 2000s, with the exception of some of the small rural carriers like Granite State Telecom, Bretton Woods, Dumbarton Telecom, all providers in New Hampshire have obtained their numbers in blocks of 1,000. Prior to that, they were getting their numbers in blocks of 10,000, and many of them still hold those 10,000 number blocks. And there are likely numbers in there that are not being used that could be made available for other residents to use, other businesses to use in the state of New Hampshire, and help increase the available numbers. What this bill does is, in essence, it closes a loophole, so to speak. So the department today has the obligation to preserve numbering resources in the 603 area code, and we have the authority to assess utilities, those that we regulate, for the costs of any consultants that we hire. In this instance, the utilities, those that we regulate, the incumbent local exchange carriers, the landline providers, they're not the only ones using numbers. And so it seems equitable that all providers that use telephone numbers in New Hampshire should contribute to the cost of this consultant that the department would hire for this investigation. We've issued an RFP. We have some bid responses in. I'm pleased to say that those responses are in the range of the fiscal note. So for a 3-year a contract, the cost would be relatively minimal, spread across all the service providers that use numbers in New Hampshire. The department's proposal at this point is to use publicly available reports that identify how many blocks, those are the 1,000 number blocks, how many numbering resources a provider has, and allocate the cost of the consultant's contract based on that. So it'd be a very minimal charge over 3 years to any of these providers. It is a one-time project-specific assessment. It's not a tax. It's not an ongoing fee. It's a special assessment for the cost of this project. Yes. I'm trying to think if I answered all the questions that came up to this point, but please go ahead.
I didn't realize you were finished. I'm sorry. Representative Bernardi has a question.
Thank you, Mr. Chair. So I guess this is the same question I asked Ms. Susie. You know, if Maine has already done this and other states have already done this, why can't we learn from them without so high a consultant cost?
Sure. Well, we'll certainly be looking to what other states have done or are considering doing. With the reorganization of the Public Utilities Commission and the creation of the Department of Energy in 2021, there was the elimination of the group that worked on telecommunications issues. And so this consultant would replace that industry knowledge and provide a much needed resource to us as we move through these processes.
So on line 26 of the bill, it says that the department may specially assess these providers for the costs of investigations and other proceedings pursuant to, et cetera. How would the department feel if we change that language to require the department to obtain funds from the fiscal committee to cover those costs? In other words, use general fund revenues rather than assessments to telephone providers.
I certainly think that's a policy decision for you all to make, and whichever path you believe is more appropriate, we're happy to follow.
And what do you think of the suggestion that was made earlier that this pooling of 1,000 block numbers be made voluntary rather than mandatory?
Yes, thank you. I knew there was a point that I had missed, and that was Mr. Rand's comment about the amendment that that he was referencing. We did see some language from the New Hampshire Telephone Association that would have added in that for service providers that have chosen to participate in 1,000 block pooling, that in New Hampshire is only the rural telephone companies. All the other companies do participate in 1,000 block pooling. So we're absolutely fine with that. As Mr. Rand pointed out, the service areas they're serving aren't the big urban centers where there's huge demand for a lot of numbers. They have their blocks of numbers, their 10,000 code to serve their customers and businesses within their communities.
Okay, let's go first with Representative Harrington.
Yeah, just so I get clear, what you're saying, right now, the tax is being paid only by the incumbent landline operators and not like cell phones and so forth?
So there is no tax.
Okay.
Right. So we have our utility general assessment under RSA 363A, which regulated telephone companies pay into based on 33% of their revenues. Other utilities pay based on 100% of their revenues. But because telephone companies are only lightly regulated, their assessment is a little bit lower. Okay?
But this
there
would-
is no such assessment
Okay.
on certain VoIP providers or on cellular providers, right? So they're not paying anything for our general work on telephone numbering, which is constant, as you may remember. Right? This would be like a consultant fee that would be specially assessed. That's under a different section of the statute whenever we have a proceeding and we need to hire some sort of expertise or even a stenographer. Those costs are specially assessed to the utilities involved, right? This would extend that special assessment to cell phone providers just for this contract, right? The landline telephone companies are already paying, right? This would just add them and sort of close the loop so that the payment mechanism is fair, and it really is quite minimal.
Follow up?
Yes.
Okay, just in general, I mean, we've been fighting this battle now for over 20 years. I make a lot of phone calls to people that live in New Hampshire that don't have a 603 area code. My daughter lives in Massachusetts. She has a 603 area code. Maybe it's just time we said, especially because you have to punch in 603 now. It's not like it was a couple of years ago. So it may be just time we say enough, give it up, and stop chasing the goal that we're going to lose on eventually, because eventually we're going to run out of numbers, and just say, we kept it 603 as long as we could. Time to say, state's too big to handle one area code. Comments?
The governor wouldn't be happy with that idea. You don't have to answer that question since it's a policy issue. Representative Kaplan.
Yeah, I mean, actually, this is probably the same question. I'm just going to word it slightly differently. I understand the iconic value of having a 603 area code and the cultural significance and what it means to people. But you mentioned an economic benefit of having the 603 area code or maybe a single area code. Can you elucidate what that economic benefit might be?
So I think, as you all most likely have seen, there's a number of businesses that market themselves with 603 in the name of their business. There's merchandise, there's mugs, there's t-shirts, there's sweatshirts, you name it, that proudly proclaim 603. To put a price tag on it would be challenging. The Department of Business and Economic Affairs is undertaking a survey to businesses in the state to get their thoughts on this, and we expect to have a report on that from them in June, but I don't currently have that information. Certainly it would.
Representative Wendy Thomas has a question.
Thank you, Mr. Chair. In your testimony, you mentioned the responsibilities of the person hired to investigate and accomplish this task. And yet, in the fiscal note, it says, does this bill authorize new positions to implement this bill? And no is checked. So what is it? Would you need to hire an additional person for this bill or not? Thank you.
There would be no additional staff, permanent full-time staff at the Department of Energy. We issued an RFP for a consultant to perform that work and to assist the existing staff at the department in these actions.
Follow up.
Follow up.
And you also just mentioned about the branding and the marketing of 603. Would a company still be able to use 603 as a branding option, even though we had more than one zip code? Not zip code, area code?
So I don't know that I'm the best qualified person to answer what their marketing strategy might be if we had a second area code and where they felt the value was in continuing to use that 603 brand.
Representative Lewicki.
Thank you, Mr. Chairman. Thank you for taking my question. Actually, I've got two questions. One easy one is NAMPA go back to the days of Ma Bell and are still doing the same fossilized thing that they did then?
I'm not familiar with what NAMPA did in the days of Ma
Well,
Bell, I confess. But the North American Numbering Plan Administrator has been around since 1947 when the whole numbering structure was adopted. There have been huge technological changes since then, and NAMPA has had to keep up with that and adopted strategies, as has the FCC.
Okay, and the second one, I've got the document here, and I know that it's not from you, but from NECTA, saying that there are, by my addition, they have approximately 1 million customers in New Hampshire. Since we have 10 million possible numbers, that means they're running at 10% efficiency. Would you agree?
So NECTA is not ubiquitous. That's the wrong word. NECTA's lines is not representative of all the lines that are used in New Hampshire. It's only for the residents and businesses that choose to use their company's services. So they represent Comcast, for example, or Comcast is part of NECTA, for example. If you're not a Comcast customer, you're not going to be in that 1 million count.
Okay, let's try to wrap this up. Representative Reynolds, you get the last question.
Thank you, Mr. Chairman. Just a quick question here. Do you have any sense of how many or like the percentage of 603 numbers are fax numbers? And would this effort involve trying to sort of recover those? You know, it's kind of a somewhat still used, but almost bygone technology now.
That's a great question. Fax numbers and paging numbers are certainly numbers that are no longer really used, but yet they're still assigned to those carriers. And so that's part of this effort to reclaim those numbers, is to get those blocks of numbers back. And I do understand from our friends in Maine that effort alone extended the life of their area code by at least 2 to 3 years. So
Great question. All right. Well, thank you very much for being here. I'm going to close the public hearing on Senate Bill 603. And because we're so far behind, I'm going to quickly open the public hearing on Senate Bill 386 and ask Senator Abard to introduce the bill to us. Thank you for being here and waiting patiently, Senator. I know you're a busy man. We appreciate that. So the floor is yours. Thank you, sir.
Thank you, Mr. Chairman. Hopefully this is an easy bill for you. In my second term, I was told that I'm going to be the chair of energy. And I remember walking into that room and looking at everybody. And I did a mea culpa. I had no clue about energy, period. Nothing, zilch. And now that I've been a few years engaged with this particular committee, it's like growing up in a house where everybody's speaking French. You understand it, but you can't speak it. And I'm pretty much at that stage. I understand when people are coming and they have some complex issues. And but one of the things that I did that first year is I put in a bill. It was a study bill, and it had to do with transmission, generation, and distribution. And so I learned that now there's a thing called storage. And so what I did is I revamped this old study, and I added storage to it. Now, why did I do that? Well, in my committee, there are 3 individuals that have never sat on energy. And I don't know if you know Cliff Bilo. Well, I was a very smart man, and this is a compliment to Cliff, a very smart man. However, as he was going through topics as though just about everybody in the committee understood what he was saying, I could see individuals wanting to choose to listen to a board being scratched with fingernails than because they had no idea what he was talking about. I could grasp some of the things. Senator Waters was there, and between the both of us, we could glean what Cliff was saying, and we definitely appreciate his input. No slight on him, but what I saw was that there was a lack of institutional knowledge, and as our legislature changes from year to year, and the changes in energy, whether it's a new department or whether there's new phrases or new things going on, I thought it was a good idea to put in another study committee, and that's really what this is. It's a study committee, and hopefully I'll chair it. And if the speaker seems wise, has an inclination as to who could benefit from this, I think that would be great. And let the departments come in and share the new technologies, new information, and get people up to speed. What are the changes? Because in 4 years, a lot has changed. And so this is just something that is bipartisan, and it'll help everybody get an understanding what's happened, what's changed. Where does the power come from? What are the big fat power lines? What are the little ones? What's distribution? What is generation? And now, what is storage? And so it'll investigate those things, and hopefully we can come out with some useful information that we can use in the next legislature.
Okay, thank you. So I served on that study committee, as you will no doubt recall.
Oh,
And we amassed a huge amount of information about generation, transmission, and distribution. We didn't do storage, obviously. But I'm wondering, is it necessary to go over all that ground again? Why not just do a study on storage?
If the committee seems that that's where they want to go, that's fine. I do think, though, that there are newbies that come in that could possibly benefit from, including the interns. When they come in, if I have a new assistant, I ask them to go back to that old report and read it so that they can come up to speed to what's going on in energy. And it's up to you. I mean, I think it would be beneficial, but it wouldn't hurt my feelings if you just kept it to storage, but that's up to you.
Okay. Additional questions? Representative Corman.
Thank you, Mr. Chairman, and thank you again, Senator Abart. Just a very simple question. I see that the bill says that the committee reports its findings by November 1st, 2024, but I don't see anything about repealing the committee. So is this committee intended to continue beyond November 1st?
Nope.
Thank you.
Okay, additional questions. Representative Kennedy.
Thank you, Mr. Chairman, and thanks for taking my question. I'm just wondering whether it wouldn't be more efficient to simply have the Department of Energy prepare a report. I mean, those are the people who are supposed to be experts here, and then any intern or whoever you would want to get up to speed could simply read that report.
Yeah, I think there's something unique about a study committee, though, especially when I run it. I'm good at it. And I think you can draw out certain things and have different departments, and if there might be industries that want to come in and testify about, say you just did storage, we can have a host of individuals come in and talk about that. I'm not going to waste anybody's time. When it comes to doing a study committee, I generate results.
Representative Munns has a question.
Thank you. Thank you, Senator. Over here.
Oh, there you are. Hey.
Hey, how are you? Why couldn't if the idea is to educate members of the Senate committee or this committee, why couldn't people just be invited to come in for a hearing and share the information that they have? I mean, if you as the chair of the Senate Energy Committee invited industry to come in and talk about storage, I'm sure that you would have a room full of people, and that would be accomplish what I think is the objective of educating people.
It's partly, but there is something unique about having a study committee and having a final report. And what we can do with that is we can, it keeps the narrative going as to far whatever's coming up, whatever we've developed. And future legislation, fixes in legislation. It's unique to have a study committee. And there are some advantages that I think that I've seen over the years as a direct result of that. Things that you haven't thought of. Yeah, somebody can present something to you. That's great. But as somebody comes in and testifies, you can come back and we can explore something maybe in a different avenue that we hadn't thought about before. Thinking outside the box. So I do like study committees. I really don't think they're a waste of time, and I don't think it's also redundant. I do think that in addition to that, when you're engaging people into questioning, coming back a few times, they're engaged in the process and they learn a little bit more, other than just sitting and listening to a lecture, if you will.
Vice Chair Thomas has a question.
Thank you, Mr. Chair. Thank you for taking my question. Again, kind of a similar question, but I'll just reorient it. I know that the pandemic really messed up our process here, and we have not recovered fully yet. But I know that in the past, we used to have presentations from various departments here for the express purpose of getting our new people up to speed on what was going on. To me, that seems like a more continuous renewal of information every 2 years versus a study committee which could present a stagnant report. Couldn't you see that as being, if we got back to that process again, being a more continuous and more up-to-date method of informing our new people?
You know, when I brought in that study bill a few years back, I remember walking into the room, into the House, and a particular state representative said, "I'm not going to teach him anything." I remember hearing her say that. She became a very good friend after that. And even we're on the opposite sides of the aisle. And I really gleaned from that. And I gleaned because she had kind of the same attitude, but she was huge in helping us out with, with information. And it brought in some type of bipartisan thing that went on there. And I can't explain it, and that's why I'm here again. I think working with her, we actually did a signing in front of the governor, and I made sure that she got her recognition because she was very, very, very important to the study. She was an institution as far as I was concerned, and I learned a lot from her. But I think that others can do the same thing, and it was almost the same kind of objections, but I think we drew out some good things from the study. So I'm pretty not adamant, but I think it's a really good idea to have a study. Yeah, if you don't mind.
Representative McGee has a question.
Yep, my question is on the timing of the bill. It says at the end where the report is going to come out, and it gives a November 1st date, but it also says that the committee should be formed 45 days after passage, right? So that could be June. So you end up in July and you're in the summer and it's election year, and you're saying the report is going to be due not even 4 full months later, which would mean you'd have maybe a month per topic. So do you think it's an adequate amount of timing for you to run a process like this?
I think if you narrowed the scope of it, yeah, maybe. If you just brought it down to storage, sure. Yeah.
Okay, thanks.
Further questions?
It's a huge topic, no doubt. And I think a lot of people, they hear things and they nod their heads, but I guarantee you about 70% of the information that comes before committee, sometimes people are like, I'm really not sure what he said, but I'm nodding my head. It can be confusing, and I just want people to be up to speed. But the chairman's suggestion of maybe just storage, I'd be happy with that.
All right, Senator, seeing no further questions, I want to thank you. And having no further pink cards on this bill, I'm going to close the public hearing on Senate Bill 396.
Thank you, everybody.
And I would now like to open the public hearing on Senate Bill 449 and call on Senator Avard to introduce, or Senator Waters to introduce the legislation.
If you get his bill, I'll introduce it more.
Okay, Senator Avard will introduce Senate Bill 449 relative to the permit issuance timeline for state air permits. Senator, we appreciate it.
Thank you very much. And for the record, I'm Senator Kevin Avard, filling in for Senator Waters because I really respect him a lot. I like him. And so here, SB 449, relative to permit issuance timeline for state permits. This bill provides the commissioner 180 days to act upon air pollution control permits applications. That's about it.
That's about it. Okay. So it replaces with a
introducing
reasonable period of time with 180 days, basically. Is that it?
I think that's about it. I wasn't prepared to do this, but just so that you folks can.
Okay, I get it. Thanks. Representative Wendy Thomas.
Thank you, Mr. Chair, and I'm not sure you're going to be able to answer this, but on lines 4 and 5, this would apply to all sources except affected sources. Can you tell me what that means, except affected sources?
I would defer to Senator Waters on that.
Thank you.
The department will be testifying in a moment, so they can answer that question. Yes, Representative Harrington.
Yeah, just to answer that question, effective sources means sources that are covered under the Federal Clean Air Act. So I'm assuming, and maybe we'll get some more information on this, that it is anything that doesn't burn anything or emit anything that would be covered under the Clean Air Act. So if you had solar or wind as compared to natural gas, wood, coal, nuclear power, because nuclear power has permits, clean air permits as well. So I think we'd be limited to those as well as storage.
Thank you very much.
Thank you, Mr. Chairman.
Okay. So the department was going to, oh, here we go. So the department will testify next. Thank you, Senator. Thought you were leaving on us, Craig. Mr. Wright and maybe some others will testify for the department.
Yes, I have a couple of guys that are much smarter than me out in the hallway, but I don't see them right now. But anyways, thank you. I'll just start off by saying again, Craig Wright, I serve as the Air Director for the Department of Environmental Services. And also with me today is Todd Moore, who just walked in the door, who's in our air permit program, and also Gary Milbury. I think Mr. Milbury will join me up here in a second. Just a couple of high-level comments on the bill. First of all, Senate Bill 449 is at the request of DES to deal with differing timelines between RSA 125C and RSA 541A. So I think, as you all remember, air permitting is one of the division's most important functions, not only under RSA 125C, but also the Federal Clean Air Act. We take that job very seriously, and I think we have an excellent track record of working with industry on our air permit program. One of the fundamental tenets we need, though, is sufficient time to work on air permits, to review an air permit application and engage with applicants. The EPA and the public is extremely important to us to ensure the integrity and transparency of the program. And with that, I was going to turn it over to Gary. I think we have a testimony letter. And Todd, could we hand that out, or did we hand that out? Sorry, we're usually a little more coordinated than this.
Well, this is our fault because we're so far behind.
Okay, so the most important thing is, I think this bill, we think, would give the department sufficient time to process our air permit applications. And recognizing that you're so far behind, maybe we'll just keep our testimony to that at this point. I know you're going to hear from the BIA. We have been working with BIA on this bill. If they have some concerns, I would just like to express to the committee that we've been working with them, and we would certainly be willing to continue to work with them in terms of finding a place where everybody's comfortable with this.
Okay.
And with that, I think we'll just turn it over to questions. I think you get the gist of what we're talking about.
Yes, I think so. So questions for Vice Chair Thomas has a question.
Thank you, Mr. Chair. Thanks for taking my question really, really quick. Can you, in the past, what was a reasonable amount of time, and was that longer than 180 days? Is that why we're making the change?
In some cases, it ranged up to, I believe, 9 months for a significant modification to an operating permit. And I believe that was the longest for types of sources we're talking about here.
Representative Corman.
Thank you, Mr. Chairman, and thank you for taking my question. So following up on Vice Chair Thomas's question, so the department is actually okay with putting itself under this time pressure that it didn't have before. This is the department's idea, put us on the clock.
So essentially what happens, because the way RSA 125 is currently written, it says a reasonable time period. Because it doesn't specify a time period, RSA 541A29 kicks in, and that gives us 60 days, which is totally unworkable for us. So we've come up with what we believe to be a reasonable time period, including, you got to realize we have to do a completeness review of the air permit application. We have to do a technical review of the air permit application. We have to draft the permit. And then we also need to go through a public notice and public hearing opportunity. So if you back calculate all those chunks of times, that's approximately how we came up with the 180 days.
Okay, before I call on other questions, I just want to give Senator Waters an update. Senator, while you were out, Senator Avard introduced the bill, and you are certainly most welcome to testify if you so desire. But since he already introduced the bill, you don't have to if you don't need to. Okay. Okay, thank you, sir. Now, we'll move along. Representative Kaplan first.
Yeah, thank you, Mr. Chair, and thanks for coming in today. This might be the question that other people also have. Could you clarify what type of installations this deadline would affect? Are we talking Title V applicants? Are we talking?
The amendment that the Senate committee approved at their initial hearing was specifically added to address Title V permits, which are really, those timeframes are more dictated by the Federal Clean Air Act and EPA. So this bill would apply to basically all other types of permits other than the Title V operating.
Representative Harrington.
Thank you, Mr. Chairman. Thank you for taking my question. Just to follow up on that, the affected sources means, covered under the Clean Air Act, but this is a air pollution control permit. So there must be some type of source that's not covered under the Clean Air Act, but also requires an air pollution control permit from DES. What would those be, for example?
So we essentially have your affected sources, which are defined in the laws, sources subject to the Title V permitting program that, like I said, EPA essentially dictates timeframes under that program. So this would cover basically your non-affected sources. These are generally your smaller sources that might have a heating system like a large boiler, maybe like a hospital or
So
smaller
size would be
commercial
the-
facilities. So we're generally talking fuel burning devices or small companies that like manufacturing companies that may emit regulated toxics that are covered under 125I.
Okay, thank you.
Representative Munns has a question.
Thank you, Mr. Chair, and thank you for coming in and taking my question. So what is it about these specific permits that's so different than the applications and permits that are covered by RSA 541, where the requirement is to have an answer within 60 days?
So when that bill was passed, I believe in the 2018 session, that essentially, unless specifically exempted, applied to any type of environmental or any type of permit that was issued, including any permits issued by DES. And as Director Wright mentioned, the issue with the 60 days is that even before we get into any real detailed review, the process requires that once we do complete a review, we go out to public notice. Some programs may, if there's a permit of interest, certain programs may require, say, a butter notification. This is air pollution, so it's a little unique. And therefore, under our programs, we need to provide public notice in a statewide newspaper, which would be the Union Leader. And then we also provide a public notice in a local paper as close to the applicant's town as we can. As you know, there are challenges with newspapers either closing or reducing to go into a weekly. So anyways, those notices have to be for a minimum of 30 days. Once we figure in the planning it takes, lead times to get it into newspapers and such, you're essentially at 40 days. And I haven't mentioned any work that we've actually done reviewing the application. So it essentially gave us, regardless of, the level of activity or number of applications coming in, regardless of the complexity, we essentially had that 60-day time frame to review every one of those applications and get out to notice. If somebody requests a hearing, we have to go out for an additional 30-day notice. So that's what essentially made the 60 days unworkable for the air permit program. And that's where we've asked for, the 180-day time frame. And then there is a provision where we can work with applicants and request more time if something does need more time, so that we can do our role in protecting public health and do a thorough review of the application. So,
Follow up. So unless the process for air permits is dramatically different than other permits covered by RSA 541, what you're describing to me would suggest that the limits in 541 need to be changed, that they're unrealistic.
I don't want to speak for other programs. There might be some programs that don't have those types of public comment periods that we may have. The requirements may be simpler. So there may be opportunities for other permits that can be processed in that amount of time. I will point out a couple things that the Air Division has done specific to air permitting, where we have reduced turnaround times. One of those is we've established a general permit for sources that are installing backup generators for backup power. We have an online registration where the permit is established every 5 years. And instead of going out and going through the typical process, we've set up what's called a general permit, where facilities that have backup engines can actually register those engines and obtain their permit through an online process. And we've reduced that where generally a permit can be issued anywhere from a couple days to a couple weeks turnaround time. That's one. And we've also got a permit by notification program for sand and gravel sources for rock crushing and screening equipment, where it's a online registration, and portable crushing plants can also use the online system to notify us if they're moving to a new location. So if complaints are received, we can follow up at that address. So those are a couple examples where we've been able to look at certain types of very simple types of permits and implement a permitting system that is where 60 days would work for that. But the 541A, 29, my understanding is that would cover different types of permit programs within the department. Some that might be an appropriate limit, but at a minimum for the traditional air permitting programs, it's just not workable. So my experience, I'd hate to go out and say 60 days doesn't work for anything. There might be programs where it does. I apologize for the long-winded response, but I wanted a couple examples.
Follow up?
Thank you. Just one quick follow-up. Is some of the pressure that you feel to get these done within the time frame, is that because of some resource constraints where you don't have the staff, you don't have the technology, infrastructure, et cetera?
I'll always ask for more resources for to increase timeliness of permitting. I think we try to balance the resources. We try to balance shifts in economic activity. For example, April is a month where we tend to receive a lot of applications for construction, sometimes the late winter months as well, so that they can go through the process and have their permit to do the construction during the spring and summer. Yeah, if you.
The only thing I would add about resources is the entire permitting program is paid by the applicants, the regulated community. They pay the fees that run the program. So if I wanted more resources, I would need to raise those fees. And I don't think that would be very popular in this environment.
Okay, additional questions. Representative Harrington.
Yeah, it's sort of like the thing that's not mentioned here. We have the not to exceed 180 days for everything except for effective sources, which we've established as covered under the Clean Air Act. What's the time limit on those? Apparently, there's none. I mean, could be 5 years, 10 years, or
Up to a year, right? Excuse me. Todd, in some cases, it could be up to a year, correct?
The initial or renewal is 1 year. That covers different types of permits. I guess this is Todd Moore speaking. I work for Gary in the permitting program. So there are some timeframes. I know some 1 year for a Title V renewal or initial permit. There's 18 months for a new non-payment NSR review permit. So it varies.
I guess my question would be, since we're changing the law to address the time frames, shouldn't we include something for, quote, affected sources, whether that's if 180 days is what you're saying is not sufficient because of all the federal hoopla. I understand that, but maybe 365 days is
Both of those
400 days or something. So there's a limit on it.
Thank you. Both of those references in the statute refer to 40 CFR Part 70, and there are timelines specified in that section. And one of them is 9 months, and one of them is longer than 9 months.
They're at the federal level, so we can't change them.
Okay. Further questions? Representative Kennedy.
Yeah, I think you partly answered this, but when I look at the Senate testimony, there was a lot of concern by small businesses that basically 180 days is too long. And I get the feeling that someone at DES said, well, if the application is simple or small, then we'll work faster. So I don't know if that's comforting enough for them or whether something specific needs to be tried to put into the bill.
So we have had ongoing discussions with BIA. I don't want to characterize those totally today, other than they have expressed some concerns about the one size fits all with the 180 days. So that's something we're certainly willing to have ongoing discussions with a subcommittee or a work session and with BIA, of course.
Well, the text on line 5 says, within a reasonable period of time and does not exceed 180 days. So that would make me to believe that it could be done in fewer than 180 days. Is that not true?
That's correct, Chair. Tradition. So I will also kind of break air permits that we're talking about today into kind of two categories. There are permits for like a new installation or a modification to equipment at a existing permitted facility. Those are considered our top priority in terms of how quickly they come in the prioritization. And then you have operating permits that the source ultimately gets after a construction permit. And those are good for a 5-year period. And when those come up for renewal, there are provisions in air permit programs, basically every state and EPA programs have a provision called application shield, where if your permit is up for renewal, if you file a timely application, the sources we're talking about today, if you file a renewal 90 days before the expiration date of your permit, you keep operating under the terms and conditions of your permit until we can take action on those renewals. So in general, what happens, and this may speak to some of the questions we got, when we're prioritizing applications for processing, your new construction and modification applications get the highest priority. We generally try to get those complete. Our goal is 120 days max. So we do have an internal goal to focus on those. And then what ends up happening is if there is a resource issue or all of a sudden there's a lot of economic activity where we're getting a lot of requests to build something, those renewals will ultimately get pushed off a little bit so that we make sure we meet our goals on the higher priority applications.
Okay, excellent. Representative Reynolds has a question.
Yes, again, one pretty quick, I hope. I know you won't have exact numbers, but how many permits of the type that are contemplated by this bill are in existence now? How many permits are out there? How many sources? And then how many new ones do you see each year? Just ballpark.
Well, I'll separate out the backup generators that I mentioned that they can register online. We have over 400 of those. Todd, would you say other than the affected, we have about 35 affected sources that we're exempting or proposing to have not covered under this. That leaves us, is it about 350 sources?
Looking at some of the information that the program put together, about 60 applications are the new construction significant amendments, which are the ones that the applicant is concerned about and they need approval for us of those per year. So around 60 per year. And then on top of that, we're doing the renewals that you mentioned Shield.
Yep.
So the applicant is not waiting for the decision to change their operations. So 60 of the ones that the applicant is really concerned about. And then in addition to that, we do, I'm not sure how many, but more than that for renewals and then all the affected source stuff that's not covered by this law.
I believe we get somewhere around, is it safe to say we get around maybe 120 to 130 applications a year? And like Todd said, about 60 of those are ones that we would be placing a higher priority on. And then the balance, we would work into our processing schedule.
Representative Lewicki has a question.
Okay, thank you, Mr. Chairman. Thank you for taking my question. What triggers the need for a permit? Is it some level of emissions, or is it,
Sure.
Because, my home generator shouldn't be.
No, in general, we don't permit residential residences at all. It's essentially your commercial, institutional, industrial facilities that require an air permit. So an example, if you have say a boiler or furnace that's rated over that burns natural gas or number 2 oil that's over 10 million BTUs per hour, which is a rating on the furnace, that requires an air permit. Just for reference, the one you have in your home is probably around 100,000 BTUs per hour. Mine's at home is like 90. I've seen them up to 125,000. So the boilers that are running on like essentially home heating oil or natural gas or propane, they would have to be over 10 million BTUs, so roughly 100 times bigger. And then we have, and then if there are certain, like if it operates on wood because of the emissions, a permit's needed if it's over 2 million BTUs per hour. Still about 20 times bigger than your typical furnace. Diesel engines that are for non-emergency purpose, some wood processing industry, sawmills and such use generators for prime power to operate their facilities. You'll see, places like most of your hospitals have air permits for their heating systems. St. Paul's School in Concord, another larger facility that would require air permits. So engines and boilers for fuel burning devices, and then manufacturing facilities. They're subject to the state air toxics law, so that's kind of a chemical by chemical review to see if a permit's needed. Fuel storage facilities, incineration units for municipal waste, most of your larger landfills because they require landfill gas control systems to be installed and managed. Those are a number of examples of the types of facilities that are power plants around the state.
Okay. Seeing no further questions for the department, I want to thank you three gentlemen for being here today to help us understand this bill. We have one more pink card, and we're going to hear next from the Business and Industry Association, and Kirsten Koch is going to tell us why the BIA opposes this legislation. Good morning and welcome. Nice to see you again.
Good morning, Chairman Vose, members of the committee. It's still morning, right? I'll be brief. I know it's been a long morning. For the record, my name is Kirsten Koch. I'm the Vice President of Public Policy for the Business and Industry Association. We serve as New Hampshire Statewide Chamber of Commerce, known as BIA. Firstly, I'd like to recognize that the Department of Environmental Services has been exceptionally cooperative and has been having ongoing discussions with BIA staff and members about the need for this change. BIA fully recognizes and is in support of the department's need for this change. We understand that there needs to be a more realistic permit application timeline, as well as the need to reconcile the conflicting statutes. However, BIA is opposed to Senate Bill 449 as currently drafted. The bill provides the commissioner 180 days to act upon an air pollution control permit application. This is 3 times longer than the current timeline of 60 days. This drastic change in timeline and the optics are especially concerning for our members that are new and small businesses. Their operations hinge on the timely approval of permits. As many of you already know, it has long been a priority of the BIA to advocate for streamlining, expediting the regulatory process. We believe the larger problem that this bill attempts to address is that the state has enacted an ambitious regulatory agenda, while the department is challenged by a lack of resources necessary to administer and keep up with these changes. The recurring solution for this problem seems to be giving the state agencies more time to make permitting decisions. However, this solution is not a financially sustainable practice for business and industry. Business's success relies on regulatory reliability and predictability. Undue delay on projects unfairly burdens property owners, developers, ultimately killing projects because in many cases the state has not yet committed the necessary resources for the agencies to, in a reasonable time frame, administer the statutes and rules it's adopted. While it is the purview of the state legislator to decide how aggressively it wants to regulate environmental protection, the amount of funding it wants to devote to it, we ask please not to shift the burden of untimely decisions onto the businesses and property owners. We do have a few recommendations. We believe that if state agencies cannot meet the deadline in statute, then applicants should receive the default approvals as provided in RSA 541-829. We see this as a guarantee for accountability on the part of the department, although that's not our preference. We'd rather they get the correct approval. To further improve this bill, it'd be our preference to work with the department to draft an amendment to establish dual tracks for air permit timelines. So whereas more complex permits would have longer timelines, less complex permits would have shorter timelines. Moreover, we believe that there needs to be protections for new and small businesses whose viability relies on these timely permitting decisions. I know the department has made comments about prioritizing new and small businesses, and we appreciate that, and we do believe that will happen, but we'd like to see that enshrined in statute to guarantee that stays a practice going forward. And finally, because this bill proposes a lengthy extension in timeline, we'd like to see the extensions beyond the established timelines removed. In conclusion, it's important to us that any changes made to this bill would be realistic and workable for both industry and the department. We respectfully request the committee allow more time for industry and the department to work together on crafting an amendment so that this bill that is necessary can pass with the right compromises going forward. Thank you. I'd be happy to answer any questions.
Well, thank you. Appreciate your input on this legislation. Questions from Ms. Koch, Representative Corman.
Thank you, Mr. Chairman, and thank you, Ms. Koch, for taking my question. I understand the idea of the dual tracks. I'm wondering, is it really feasible to establish in statute the actual criteria for the dual tracks?
Thank you for the question. That's something we've been discussing with the department, and I think our engineers and our membership are reviewing as well. It's something we like to work on going forward with the department.
Follow up?
Yeah, I'm just wondering, does it make more sense to have it as a rulemaking rather than in statute?
Thank you for the question. I think that's probably a decision for the committee to decide.
Representative Kennedy has a question.
Thank you, Mr. Chairman. It's just very similar. I mean, I guess you are not totally comforted by we'll do it faster. So you do have a plan for adjusting the bill. And, I had the same thought as Representative Corman that maybe that could be put into a rule.
Okay, further questions, Representative Harrington.
And thank you, Mr. Chairman. Thank you for taking my question. First one, what's going on now? We have a 60-day limit. They want an extension for tripling that amount of time. So I have assumed most permits aren't issued within 60 days?
Thank you for the question. So I think first, there's a problem with conflicting statute. There's one statute that says this needs to be done in a reasonable amount of time, and there's one statute that says this needs to be done in 60 days. And it's my understanding that most of these permits, or at least the more complex ones, cannot be done in 60 days.
Okay. Follow up?
Follow up?
Now, you've listed a number of things here. Is BIA prepared to give something that could be implemented this session, or are you basically saying, let's put this on hold, get back with the department, and come up with some way to implement these proposals that isn't going to be able to be done in the next few weeks? Is that an accurate statement?
Thank you for the question. We're prepared to work on amendment with the department this week. I mean, it's something that we're already discussing how we can do this right away. So we'd like to have an amendment ready for the committee very soon.
All right, thank you.
Representative Kaplan has a question.
Thank you, Mr. Chair. That was basically my question, but I guess I'm going to ask you, did you run out of time in your discussions with the department? Is that why you need extra time in order to do this?
Thank you for the question. I think this bill, when it was in the Senate, it flew through the committee. It was voted on the same day that the public hearing was, immediately after. And so we thought there may be an opportunity to do something like this in the Senate. Unfortunately, there just wasn't the time to do it.
Representative Munns has a question.
Thank you, Mr. Chair, and thank you for coming in. And I want to thank you for highlighting the fact that a lack of resources is at least a part of the problem, because I think that is an important consideration. And the only thing that I guess I would ask is that if you're working with the department on an amendment, which is wonderful, please give some consideration to how we address that resource constraint, including how we pay for it. Thank you.
Thank you.
Additional comments, Representative McGee.
Thank you, Mr. Chairman, and thank you, Ms. Cook, for being here today. I just want to note that we already heard that on the other side of the wall, there's a lot of pretty faces there, so maybe they didn't have any questions for you, but we do. In the testimony from the Department of Environmental Services, Air Quality Division, they mentioned some of the statutory requirements that they're required to meet in order to process some of these complex or new applications, including application completeness, a technical review, public notice, all of which take literal time, and then, crafting and issuing the permits. So I agree that there may be resource issues in terms of there being a choke point that only certain people are doing that work. But I still am not sure. I'm not sure about the conclusion that there aren't circumstances under which a 6-month period would be needed for a particular permit, and that they might be able to decide that.
Thank you for that. I don't think that we dispute that there are some cases where there's more time needed, especially on very complex projects and when they need to do the public notification requirements. Our goal here is to come up with a timeline that's reasonable for both industry and the department, and we don't want to suggest anything that creates a condition that they can't work under.
Thank you.
Additional questions for Ms. Koch? Seeing none, I want to thank you very much for giving us your perspective on this legislation, and I'll look forward to hearing how amendment negotiations go.
Thank you.
With an idea toward their being extremely timely. It's possible that we may exec this bill a week from today, Monday, the 22nd of April. So I'll just throw that out there in case that helps move things along. Okay. With that, we're going to close the public hearing on Senate Bill 449. And we will now take an extended lunch break. I know some of our Democratic colleagues have another meeting they need to go to. The Republican members of this committee will hang back in the room for a caucus, and we'll see the rest of you at 2 o'clock for exec session. Thank you very much. Time to resume ST&E's session for April 15th of 2024. This afternoon, we're here to conduct executive session on 5 bills. Senate Bill 303, Senate Bill 388, Senate Bill 391, Senate Bill 451, and Senate Bill 540. So I'm going to open an exec session on Senate Bill 303. And I'm going to recognize Representative Notter for a motion.
Thank you, Mr. Chairman. I move ought to pass.
Chair recognizes Representative Harrington.
I second that motion.
Moved and seconded that we adopt the motion of ought to pass on Senate Bill 303. And I'd like to open the floor to comments on the motion. Anybody have anything to say? Okay. In that case, I will just point out that this bill is essentially was requested by the Department of Energy and is a bill to clarify the use of monies that flow into the Renewable Energy Fund. And it makes the department's use of those funds, clarifies the department's use of those funds to achieve the purposes of maximizing the benefit of renewable energy, especially with regard to low-income solar and other low-income projects. Is there any further discussion on this bill? Well, seeing none, I'd ask the clerk to call the roll on the question of ought to pass on Senate Bill 303.
Vice Chair Thomas.
Yes.
Representative Notter.
Yes.
Representative Harrington.
Yes.
Representative Lewicki.
Yes.
Representative Melvin.
Yes.
Representative Bernardi. Yes. Representative Ploget.
Yes.
Representative Summers.
Yes.
Representative Kennedy.
Yes.
Representative McGee.
Yes.
Representative McWilliams.
Yes.
Representative Partial.
Yes.
Representative Kaplan.
Yes.
Representative Munns.
Yes.
Representative Noel.
Yes.
Representative Thomas.
Yes.
Representative Corman.
Yes.
Representative Reynolds.
Yes.
Chairman Bose.
Yes.
19-0.
Okay, by a vote of 19-0, the committee adopts the motion of ought to pass on Senate Bill 308. Without objection, we'll put this bill on the consent calendar.
You want to introduce Charlie Mellon? Okay.
So I forgot at the beginning of this session to introduce Representative Charlie Melvin, who is sitting in this afternoon for Lex Berezny. Thank you for being here, Charlie. Appreciate it. Who is missing though? Oh, Representative Cretion is missing. Okay.
Yeah.
All right. Thank you. So Representative Notter will write the committee report for Senate Bill 308. And with that, we'll close that exec session. And now we'll open an exec session on Senate Bill 388 FN. And I am going to move ought to pass on Senate Bill 388 as amended by Amendment 2024-1496H, which is circulating in your direction even as I speak. And while you are awaiting the arrival of the printed copy of the amendment, which was provided to all of you electronically last Friday, I will point out that this also is a bill that was requested by the Department of Energy. And what this bill essentially does is that it clarifies the net metering community solar project section of the net metering statute and adds language about new solar arrays, changes the reference to homeowners to households, which is more appropriate, and adds some references to the fact that projects that are ready to go will receive preference by the department. Representative Thomas?
You need to get a second.
Oh, sorry, I didn't get a second. Okay, so I recognize Representative Thomas.
Second.
Moved and seconded. Now I'm going to move the adoption of Amendment 2024-1496, and I recognize Vice Chair Thomas.
Second.
Okay, now we can discuss the amendment. So the last thing that the other thing that the amendment does is it adds the text by rule or order in two places under RSA 362 F:2, paragraph 15A. This is the RSA that we modified last year to bifurcate small and large boilers for their qualification for RECs. And the department realized after that legislation was passed that they really needed this extra text. And so they've asked us to include that. And the amendment does just that. So with that, I'll see if there's any comments that anyone has to make about the amendment. Representative Thomas.
Thank you, Mr. Chair. I just wanted to clarify the by rule or order. So can you just tell me what the order who the order would come from? Is that an executive order?
No, that is a Department of Energy order. So if there is a proceeding within the Department of Energy that makes some kind of a decision, they typically issue an order codifying that decision. The PUC does the same thing, and other agencies probably as well.
Thank you.
Further discussion? Seeing none, I ask the clerk to call the roll on the question of the adoption of the amendment 2024-1496H.
Vice Chair Thomas.
Yes.
Representative Nodder.
Yes.
Representative Harrington.
Yes.
Representative Wicki.
Yes.
Representative Melvin.
Yes.
Representative Bernardi, yes. Representative Ploget.
Yes.
Representative Summers.
Yes.
Representative Kennedy.
Yes.
Representative McGee.
Yes.
Representative McWilliams.
Yes.
Representative Partial.
Yes.
Representative Kaplan.
Yes.
Representative Munns.
Yes.
Representative Noel.
Yes.
Representative Thomas.
Yes.
Representative Corman.
Yes.
Representative Reynolds.
Yes.
Chairman Bose.
Yes.
19-0.
By a vote of 19-0, the amendment is adopted. I now move ought to pass as amended and recognize Vice Chair Thomas.
Second.
Moved and seconded that we adopt the motion of ought to pass as amended for Senate Bill 388, as amended by Amendment 1496H. Any further discussion needed? Seeing none, I ask the clerk to call the roll on the question of ought to pass as amended by Amendment number 1496H on Senate Bill 388.
Vice Chair Thomas.
Yes.
Representative Nodder.
Yes.
Representative Harrington.
Yes.
Representative Wicki.
Yes.
Representative Melvin.
Yes.
Representative Bernardi, yes. Representative Ploget.
Yes.
Representative Summers.
Yes.
Representative Kennedy.
Yes.
Representative McGee.
Yes.
Representative McWilliams.
Yes.
Representative Partial.
Yes.
Representative Kaplan.
Yes.
Representative Munns.
Yes.
Representative Noel.
Yes.
Representative Thomas.
Yes.
Representative Corman.
Yes.
Representative Reynolds.
Yes.
Chairman Bose.
Yes.
19-0.
Okay, by a vote of 19-0, the committee adopts the motion about to pass as amended by Amendment number 1496H. And I will write the committee report. And without objection, we'll put this on the consent calendar. Seeing no objection, it goes on to consent. And with that, we'll close that executive session. And next, we'll open an executive session on Senate Bill 391. And the chair recognizes Representative McGee for a motion.
Yes, I'd like to make a motion of ought to pass as amended.
And I will second that motion. I think I just recited a song lyric, didn't I? So, Chair recognizes Representative McGee for a motion on an amendment.
Yes, I'd like to make a motion of ought to pass on amendment 2024-1491H.
And I second that motion. So it has been moved and seconded that we adopt amendment number 1491H. And if you so desire, Representative McGee, I'll give you first crack at discussing the amendment. If not, I'll do that myself. Okay. So what this amendment does is it adds three key things to the original bill. On line 5, it adds text that says within 60 days of the effective date of this section, the Department of Energy shall open a proceeding. So that the text within 60 days of the effective date of this section is new. And then on line, starting midway through line 9 and going down to midway through line 12, there's new text that says, the department shall provide the chairpersons of the House Science, Technology, and Energy Committee and the Senate Energy and Natural Resources Committee with status updates regarding the proceeding every 6 months after opening the proceeding until rules are adopted by the department. So that's new text. And essentially that will allow our committee and the Senate ENR committee to keep tabs on this proceeding to make sure that it stays on track. And then the final new text is on line 18. Actually, it starts at the very end of line 17. And it adds, and shall be submitted to the Joint Legislative Committee on Administrative Rules within 15 months of the effective date of this section. So essentially what that says is that this proceeding should not take any longer than 15 months. It doesn't have to take 15 months, but 15 months is the longest it should take. So those are the changes that the amendment makes to the original legislation. Anybody have comments on those changes or on the amendment? Representative McGee.
Thank you, Mr. Chairman. Yeah, I'll just say that, the need for rules and the discussions around the issues that we're having with interconnection in the state were totally uncontested in the hearings. What was at issue was the time scale that people would have to be facing moving forward, and that was where there was push and pull in terms of what could be delivered in what time frame, and how aggressive we could be in trying to at least get the rules established so that the interconnection queues could start to be dealt with in a more consistent way and hopefully a shorter time frame. So one of the things that we contended with was when we would require the rules to be delivered. And the negotiations actually started at 18 months, which there are quite a few people in the queue who've been waiting quite a significant amount of time now. So we wanted to be mindful of what the Department of Energy felt they needed in terms of their resources and how they're approaching this rules process. And so the compromise was made really, they say the best compromises are nobody's happy. That is this bill or this amendment. So that's all I have to say.
Thank you. Additional comments, Representative Munns.
Thank you, Mr. Chair. While I think it's great that there are some defined timelines identified, and that's a real positive in terms of this amendment. It is disappointing that the way the bill or the way the amendment is written doesn't really take advantage of what hopefully has been a lot of discussion and dialogue that's been going on around this issue. The fact that the amendment is worded so that the proceeding will start 60 days after the effective date of the bill, it just seems like an artificial delay. And I would have liked to have seen a little bit more urgency in moving things forward. Hopefully, if we pass this today, which I suspect we will, hopefully the department will take that as a sign that this is going to move forward, and they will get started on actually moving this issue forward, because it's a major issue that businesses and homeowners across the state have expressed concern about, and we really need to address it.
I agree that this is a significant issue. I do, 100%. And you guys are going to think I'm weird for bringing this up. But this morning, I actually looked at RSA 541A. I've read it on numerous occasions in the past, but I hadn't looked at it for a couple of years. And I looked at it to kind of just refresh my memory on just what is involved in the process of drafting rules. And among the things that I was reminded of by reading RSA 541A is that before you start a rule proceeding, you actually have to notify the public. You have to put out a notice that you're going to start a rules proceeding. And it has to be 30 days, I believe, or maybe even 60 days before the proceeding begins. And then once the proceeding, once the drafting of rules has begun, and you have some rules to show to people, you actually have to have public comment periods. And all of those public comment periods take time. So to restrict this proceeding any further than 15 months, I think would make it difficult for the department to complete the process according to the prescribed legislative procedure that's in the Administrative Procedures Act. So I think 15 months is a reasonable amount of time to give the department the time it needs to do what it needs to do. Further comment on either the amendment or the bill? Representative Corman.
Thank you. It's actually a question on the last sentence in both the original bill and the amendment. Any new employee positions required to implement this chapter shall be approved by the Fiscal Committee of the General Court. And I forget if we discussed this before. Does that mean that the Fiscal Committee has no latitude and must approve them, or is it more that they're subject to approval?
I personally believe it means the latter, but you're prescient in bringing that issue to the forefront. It is an interesting question. Mr. Shulock, would you like to give us your opinion about whether that sentence means that if the department goes to the Fiscal Committee and says, we need another position, they have to give it to you? And could you come forward to respond to that? Thank you.
I'll give you a lawyerly answer. I don't know if they're constitutionally required to give it to us, but I expect that they would if they believed that we needed it.
So basically, you're saying if you make a good case that you need that person, then you'll probably get it.
Well, there is a reason why we keep arguing for more time to do this. We are resource constrained. So,
okay. Does that answer the question for you, Representative Corman?
As well as possible.
Okay. Further comment on this? Thank you, Mr. Shulock. Further comment on the amendment? Seeing none, I ask the clerk to call the roll on the question of the adoption of Amendment 2024-1491H.
Vice Chair Thomas.
Yes.
Representative Nodder.
Yes.
Representative Harrington.
Yes.
Representative Lewicki.
Yes.
Representative Melvin.
Yes.
Representative Bernardi, yes. Representative Ploget,
Yes.
Representative Summers,
Yes.
Representative Kennedy,
Yes.
Representative McGee,
Yes.
Representative McWilliams,
Yes.
Representative Partial,
Yes.
Representative Kaplan,
Yes.
Representative Munns,
Yes.
Representative Noel,
Yes.
Representative Thomas,
Yes.
Representative Corman,
Yes.
Representative Reynolds,
Yes.
Chairman Bose,
Yes.
19-0.
By a vote of 19-0, the amendment is adopted. And Representative McGee, I recognize her for for a motion.
Oh, yes, I'll make a motion for OTPA.
I second the motion of OTPA. Is there any further discussion needed? Seeing none, I'll ask the clerk as soon as he has his paperwork ready to call the roll on the question of ought to pass as amended by Amendment 1491H, Senate Bill 391.
Vice Chair Thomas,
Yes.
Representative Nodder,
Yes.
Representative Harrington,
Yes.
Representative Lewicki,
Yes.
Representative Melvin,
Yes.
Representative Bernardi, yes. Representative Ploget,
Yes.
Representative Summers,
Yes.
Representative Kennedy,
No.
Representative McGee,
Yes.
Representative McWilliams,
Yes.
Representative Partial,
Yes.
Representative Kaplan,
Yes.
Representative Munns,
Yes.
Representative Noel,
Yes.
Representative Thomas,
Yes.
Representative Corman,
Yes.
Representative Reynolds,
Yes.
Chairman Bose,
Yes.
18-1.
Okay, by a vote of 18-1, the committee adopts the motion of ought to pass as amended on Senate Bill 391 as amended by Amendment 1491H. And Representative McGee will write the committee report. And without objection, I'll put this on the consent calendar. Hearing no objection, it goes on to consent. So we'll close the executive session on Senate Bill 391. Now, let's open an exec session on Senate Bill 451. And I have some amendment text to pass out here to people. Okay. So the chair recognizes Representative Thomas for a motion.
Thank you, Mr. Chair. Motion OTP.
OTPA?
No, we haven't done the amendment yet. So it should be OTP at first.
You have to pass the amendment first, don't you?
No, we have to open it up for we have to open.
I always get confused by this. Are you supposed to move OTP, OTPA, move the amendment first? It's-
Open up OTP, then you introduce the amendment.
OTP on the amendment.
Okay. So Representative Thomas moves ought to pass on Amendment 1501H. And Representative Harrington is recognized.
Here we go. I have a question. I haven't had much chance.
I need a second first.
Oh, okay. Well, I'm not seconding.
Representative Bernardi is recognized.
I second the motion.
Moved and seconded. Now Representative Harrington.
Try this again. On page 3 of the amendment, starting at line 30, all state agencies having permitting or regulatory authority shall make and submit the committee a final decision on parts of the application that relate to their permitting and other regulatory functions no later than 120 days after the application's been accepted. We just heard a bill this morning saying that air permits weren't going to be required for 180 days. So it sounds like something's in conflict here. That's what the DES said they needed to have. So since air permits could be a part of something that is covered by this bill, we seem to have a conflict here. And there's also says within 180 days of the acceptance of the application, the committee shall issue or deny a certificate for energy facility. Again, if the air permit's going to take 180 days, I don't see how the committee can finish it on the same day that they get that. Now, I realize there's a caveat at the end that says something to the effect, times for conducting public hearings, rendering a decision on the application may be extended for good cause upon written request of the applicant. It doesn't say anything about the committee being able to extend that date. So if we're going to have 180 days for air permits, we can't say you have to have them done in 120 days. One of those has got to give.
Well, I assume that this is referring to the application before the site evaluation committee.
I have to differ.
And-
All state agencies having permitting or other regulatory authority, that includes DES issuing an air permit.
Yes, I understand that. But this particular legislation refers to the site evaluation committee. And if my memory serves, elsewhere in the SEC legislation, and I don't have the entire statute in front of me, it basically says that all state agencies having permitting or other regulatory authority have to make and submit to the committee a final decision on the parts of the application that relate to its permitting with a longer time frame. This only applies to the fast track section of this legislation. And so it does shorten the time frame. Now, will that conflict with the bill that we just passed earlier? I don't know. I don't know the answer to that. And there's nobody from DES here who could shed any light on that question.
Mr. Chairman?
Yes.
DES was party to the discussions around the changes that would happen in the fast track bill for the SEC process for existing facilities that are being repurposed. And they did provide input on that. So I think that was part of the reason that the language towards the end was listed that for good reason in writing. If somebody had to have a delay, they could. But I think they are trying to hold to a tighter process because they think that it'll only be in exceptional cases where the example that was given in our meeting was that if we were looking at converting to, say, a hydrogen facility, you would need the Army Corps of Engineers, and they would not be able to turn that around in a tight time frame because there's a base time limit that you get with that particular interaction. But in most cases, they didn't think that the permitting time frame would be elongated because in many cases, the plants would be probably less concern in terms of the technologies that they're turning towards. That was the only example they could really think of where it would probably be a more extensive effort in terms of the permitting process.
Yes. I think it's a good catch by Representative Harrington, and I wonder if Mr. Shulock, if you would have any comment on a potential conflict between language in Senate Bill 449, which we heard this earlier today, that wants to give air permitting 180 days versus the language here that wants to limit it to 120 days.
So I'm not familiar with the other bill. I can say that for these facilities, there is an expectation that most of them are not going to require air permits, right? That for the most part, the projects that are expected to be developed over the next several years will be renewable facilities, right? And so that specific conflict shouldn't be a problem. But there should be language, if I scribed everything and got everything in the email to folks correctly, there should be provisions that allow for an applicant to to extend the time, right? So if DES requires 30 more days in order to approve a permit, then the applicant would simply request that extension.
Yes, I believe we saw that
Yeah. And-
language in the bill.
So yeah, there are plenty of opportunities to extend if an applicant needs it. The SEC citing wouldn't need to fail. The reason for allowing the applicant to request that extension is so that outside agencies don't feel the need to deny a permit within that 180 days just because they can't make it, right? So or the 120 days, whatever it is, right? So the applicant can simply ask for an additional amount of time so that their application doesn't fail before the SEC.
Okay, thank you. Representative Harrington, does that answer your question?
Not really. That seems to be reverse logic. A couple of things. First, renewable covers wood. So we could take like we did earlier in New Hampshire, and we converted I think it was a coal plant into a wood burning plant. It would require a different air permit, whole different types of emissions. That would be renewable, and that would require the air permit that we say they have 180 days to give. This says you got to do it in 120. And I really don't think we want to be in the position of telling applicants, well, you're going to be denied the permit unless we can exceed the amount of time by law that we're allowed to look at this, because otherwise we'll just have to deny it because we don't have enough time to do it. Well, if you don't have enough time to do it, then you ought to improve the process or change the law. But don't just say, well, if you write a letter to us saying you're requesting an extension, even though you don't want an extension because it's going to cost you a lot of money, but if you do that, then we'll keep working on it, and maybe 6 months from now you'll get your permit. But otherwise, we're going to just deny it. That doesn't make any sense, putting that into law, that logic to me. I think this needs more work.
If I may, the SEC wouldn't be the agency denying, it would be DES that would say, we don't have enough time, right? So DES asked for the ability for the applicant to request the extension effectively without a denial, right, from the SEC, so that the SEC process and the DES process could continue in concert.
Follow up? That would mean,
Yes,
why
follow up.
even have a number in it all? Because if the DES decides, well, it's going to take 6 months for this permit because we're not going to get around to it for a while, so you can either have your permit denied or you can request a 6 months extension. It becomes totally meaningless to put a number in there if the recourse of the applicant is to say, oh, well, you're going to deny the permit unless I agree to give you more time. Then why even bother putting any kind of a deadline in? Because it's totally meaningless. I just think this needs work. It needs to be something needs to be fixed.
Representative McGee.
Yeah, I was just going to say, I think the reason that there's a time frame in there is because all the parties that were there discussing the bill the intent of the bill was to try and create a process that would fast track repurposing of existing facilities that had already been cited by the evaluation committee. So there would be exceptions if there were items that needed to be permitted that were distinct from what was already at the facility site. But the idea of having a shortened time frame was really the intent of having something in legislature that would be a separate process from what we did in 609. So I think that was kind of the driving force, which is why there's a number in there. At least that would be my explanation. That why they were trying to quantify it in terms of how long they wanted the process to be, sort of the standard process. But then they had to allow for exceptions because they didn't want people to be turned away because of a process that was outside of the norm. But they wanted to define the norm as being a short process.
Well, we could consider changing the 120 days to 180 days, but then we'd have to change the 180 days on line 33 to some longer date, like 210 days or something. Would that be a potential fix? Mr. Shulock, do you have a comment?
Whether extending the lines would fix it. I think it would address Representative Harrington's issues if the deadlines were extended to accommodate the time necessary to grant an air permit. Whether that works for everybody in the group, it's not a department. The department isn't responsible for the bill. We helped with the drafting, et cetera, but the people who would like, who are supporting the bill may have something to say about that.
Okay.
I can't answer.
Thank you.
Yeah.
Representative Reynolds, you have a comment?
Yes, thank you, Mr. Chairman. I respect the point that Representative Harrington is making, but I ask, wasn't the 180 days deadline in the bill that we considered this morning considered the maximum time that DES would be allowed to have to issue a permit? And the point of this bill, including 120 days, is that we're trying to give some urgency to these repurposing. So I don't really see that it's inconsistent.
I see Representative Harrington's point. So at this point, I think we're looking for a fix. Representative Kaplan.
Thank you, Mr. Chair. I believe the bill we passed just today on the air permits included an exception for, or it didn't really include Title V permits for air emissions. And I might be mistaken, but I think most power plants and most wood burning plants would be looking for a Title V permit because of the amount, because of the type of emissions they are emitting, and so that's something that comes under the Federal Clean Air Act, and we don't know the timeline for that. So, and when I'm looking at this, I think that the perfect shouldn't be the enemy of the good, and we should just go with the built-in escape valve, if you will, of requiring the applicant to ask for an extension.
Good point. We didn't adopt 449 this morning. We just heard it, but I think you're right about Title V. Representative Munns.
Thank you, Mr. Chair. I wasn't going to bring these up because they're really not significant, but if we were to consider a change, an additional amendment, there is a typo on line 1, on page 1, line 15, that we might want to fix. The modified energy facility would either, I think we need a B there, BE, be permitted. So that's one minor issue. And then on page 5, this is a little bit more substantive. Again, I don't know that it's what I would consider something to hold up the amendment if everybody is comfortable with everything else. But at the top of the page, we talk about a public information session in the city or town where the particular case is pending, which is something we had talked about during our work session. And so we made the change there so that the meeting in the county would be in the town where that's most affected. We made the change at the top of line 5 in lines 2 and 3, but we did not make the change at the bottom of the page where we also talk about a public hearing in each county. So again, if we were going to request an additional amendment to address other concerns, I'd want to have us try to fix that as well. Does that make sense?
Yes, except where at the bottom of the page?
Bottom of page 5, line 33, where it says that the site evaluation shall hold at least one public hearing in each county. Oh, in which the proposed facility is to be located. And the idea was to have it be in the town in the county where the facility was located. We did it up top, but we didn't do it at the bottom. But I don't want to be the sole reason for an amendment.
I have a question on that.
Yes, Representative Harrington.
Yeah, can someone explain to me what this means? That top sentence there on page 5? It says at least one public information session in each city or town in the case of a purposing and otherwise in each county. What is a it's in the case of a purposing is what mine says. I don't know what that means.
should be repurposing, I think, is what was agreed to.
Because purposing doesn't make any sense there. I mean, I don't know what purposing is.
Mr. Chair?
Yeah.
Can I try to address
You
that?
can help by all means.
I can't.
Go ahead.
I hadn't caught that. I mean, you're right. It should say repurposing. I know the intent was that the required information session to be held in the county of the proposed facility would be in the town where that facility was located. That was the intent. Now, I don't know if maybe the wording could be cleaned up.
And actually, line 26 on page 5 also talks about a purposing.
The actual term as defined is a qualified repurposing. So maybe that's the term we should be using throughout the bill. If you look on line 5 on page 1, that's defined.
In fact, on page 1, starting on line 7 and going to page 2 through line 4, that's all new text that was added to this amendment to clarify just exactly what qualified repurposing means. So that's one of the more important parts of this amendment is that text that I just outlined from 7 on page 1 to 4 on page 2, through 4 on page 2. All right, so it sounds to me like maybe we need to do some more work on this amendment before we move forward. Or we could move forward. Representative Corman.
Thank you. I also just find the amendment as written unclear that it does apply to a qualified repurposing. So if you look at page 2, line 7, the heading for 162H7A says qualified existing energy facilities repurposing, but nowhere else in here does it say that all this procedure applies only to qualified repurposing. It's just listed in the header. It doesn't say these things apply to repurposing. And then when you get to page 5, line 26, 1B, it says, except in the case of a qualified repurposing. So apparently there's something about when there isn't a qualified repurposing. So it seems to be a bit mixed up about what's applying when.
So would you be advocating that the word repurposing be inserted before the word application on lines 10 and below?
Which page?
Page 2.
Page 2.
So instead of saying upon filing of an application, it would say upon filing of a repurposing application or qualified repurposing application.
Well, I mean, the issue I have here is if you look at line 8 of that page, it says all applications for a certificate for an energy facility. So it's not saying, it's not restricting it only to the qualified, right? I think we need something that says Section 7A applies to qualified repurposing. Yeah,
Okay.
qualified
Yeah, I take your point.
Yeah, I think it just needs to say that, and then of course what I said about on page 5 where it says except in the case of a qualified repurposing. So why are we saying except in the case?
Mr. Monahan, could I ask you to come up to the microphone and let us know whether you think such clarifying language is necessary here?
I don't have a copy of the amendment that you're working with. So
We can get you one. This is essentially the text that
yeah, and I'll jump right into it. I think RSA going from memory here, but it got chilled in my head last week. The, is it 162H7A is a new section, right? So it only applies to the qualified repurposing. So,
So what Representative Corman is suggesting is that maybe we need a new section 1 that says the following applies only to qualified repurposing, just for clarity.
I think, yes, I think for clarity purposes, that makes sense. I don't know that it's necessary, but again, I'm looking at this version for the first time. The intention was that 162H7A only applied to the qualified repurposing track.
But given the fact that 162H is an extremely long and complicated RSA, to eliminate the possibility that the fast track section and the regular section don't get confused, maybe it's worthwhile to point out that this applies only to the fast track.
Yeah, no, I think perfectly fine. And as we've said from the beginning, we want to make sure that the site evaluation committee has as much guidance as possible. So I think that's a very helpful change.
Okay, thank you.
And I would say in that case, when we go back to page 5, line 26, where we have this bolded language, except in the case of a qualified purposing, which maybe should be repurposing, do we even need that if the assumption is that everything in 7A is about qualified repurposing?
Yeah, except that by the time you get to that text on page 5, line 26, now you're in a different section of the RSA. Now you're in RSA 162H10, right? So
Good
maybe
point.
that text does need to stay there.
Good point, thanks.
Yep. Okay, so applies only to qualified. Okay, further comments from the committee? Representative Corman.
Yeah, so given that, when I look at page 4, starting on line 4, 162H7B, role of state agencies, that section applies to all site evaluation, not just the fast track ones. Is that correct?
Any clarification on that, Mr. Monahan?
I'm looking back at Dave, maybe if Dave Schulak joined me because we worked in this language together.
Yes, Mr. Schulak, could you come up, please?
And I'm just a little hesitant to jump right into an answer because I don't have the full statute in front of me, so.
Yeah, it's a little hard seeing it today, even in print,
Yep.
right?
So
Although we worked on it.
the question is on page 4, beginning in line 4. When we're talking about the role of the state agencies, that is just for the fast tracks provisions of the new law?
No.
Okay.
162H7B would apply to everything.
So then the fast track is really only 7A and the definitions earlier.
That's correct. And then the definition, and then some of those minor changes that you see in 162H10, right? And there is a difference between notice. Notice is given in the town, but the hearing is held in the county, the way that this is written, right? And that is, it's written, it can be changed. I'm not saying it can't be changed, but the reason that it's written that way is because that section does apply to all hearings, which would include transmission hearings. And sometimes those transmission facilities span multiple municipalities, and it's inefficient to have that in every town as opposed to in the county where most of those municipalities are likely located.
Mr. Chair, could I address that?
Representative Mims.
I understand what you're saying, and I certainly wasn't arguing that we'd want to have a hearing in every town. The whole reason for having it in the town where the repurposed facility or the facility is located is, it just makes it more convenient for the people that are most affected to be able to get there. That's the whole reason.
And that fix could probably be drafted. It's just not in there currently.
Yeah, certainly you'd unfortunately have to distinguish between what this is mostly about, which is a facility, an existing facility that's in one town or one location. I understand where you'd need the ability for a pipeline and transmission line to be in the county.
Well, Mr. Schulach mentioned transmission. Let's assume that National Grid sold their existing transmission line that runs through the state to a different company. And that company wanted to repurpose that transmission line to, I don't know.
Direct current.
What?
DC.
Yeah, direct current. Would that require site evaluation committee approval to do that? And would that be covered by this repurposing statute?
I don't have the statute here in front of me. It would depend on the length of the transmission line, all sorts of variables.
Okay. Well, something worth considering, I guess. All right, Representative Munns.
Sorry if I opened up a Pandora's box. I have a question on page on page 2, line 3. One of the elements of the definition of a qualified repurposing is that the applicant demonstrates that the modification may result in qualitative improvements in the health and safety of the state or the system reliability in New Hampshire. I guess I have two questions about that. One is, how do you demonstrate that? And then the second question is, can you demonstrate that before the fact, or is it demonstration after the fact? I mean, you don't really know what's going to happen. So I guess my first question was, do we need to be a little bit more specific in terms of what demonstrate means?
So I think, yeah, this was among all the parties who worked on this language, this was an important part to be included. I think it's important to understand this is part of the application to make it into the fast track process. But then when you look at the 5-part criteria that the site evaluation committee has to use to approve everything, it includes a more substantial consideration of the issues around public health and safety, financial, managerial, things like that. So just like everything else in the application, you need to, during the process, once it's filed, you need to demonstrate that it's true and accurate. And
Representative Summers has a question.
Just a quick question, just because of confusing going back and forth, should there be a defined definition of what is part of this amendment is in fast track and what is throughout all, including fast track?
Yeah, we kind of addressed that a moment ago when we talked about adding on line 8, a new section 1 that says that this section, H:7A, applies only to qualified repurposing applications. It's kind of hard looking at this amendment to realize that this is part of RSA 162H, which right now is about, I forget how many pages, 30 pages long. So taking this out of context of that larger picture is a little confusing. So, and I'm not saying that you're confused, I'm saying it could be confusing to all of us.
but
So.
but a 75-page amendment would have been equally confusing, I think.
Yeah, a 75-page amendment would have been really confusing, so. All right, further, Representative Harrington.
Getting back to what was just mentioned there, I tend to agree that we need, and that's on line 3, On page 2, the applicant demonstrates the modification may result in qualitative improvements in the health and safety of the state or to system reliability in New Hampshire. Far-fetched case, but let's say someone repowers a wood-burning plant with coal. Now, that may add to the system reliability of New Hampshire, but it's probably not going to add to the health and safety of the state. So you could do one without the other. So the way this is written, you'd only have to qualify for one. So you could reduce the system reliability in New Hampshire as long as you made improvements to health and safety, or you could increase the system reliability regardless of what effect you had on health and safety. I think that statement is way too vague, and it's an either or. You can meet one of two requirements. You don't have to meet both.
So how about if we change the word or to and? Improvements to the health and safety of the state and to system reliability.
That's an improvement for sure, but it's a very vague, loosely defined term on health and safety and system reliability. There is no formula you push it into and say, count out the crank. Oh yeah, the system reliability went from 8.4 to 8.5, so we've improved it. And the health and safety went from 3.0 to 3.6, so we've improved it. It's totally arbitrary. It's in the eye of the beholder, I guess.
Mr. Monahan, you said that this line was important to some of the stakeholders. Could you elaborate on that?
Yeah, I think that there were, as the committee may know, there were some folks that were concerned that were advocating that this change only applied to facilities that were going to repower with renewable or clean energy. I felt as though, and I think most of the people that worked on that felt that that was didn't belong there because this is essentially a land use bill, and anything that deals with emissions belongs in another part of state law. And so the suggestion that I think I made was to use health and safety, but I didn't make that up. Those are requirements that already exist in other parts of the siting law, and so we're repeating what already exists. And I apologize, I don't have the whole RSA 162 in front of me, but it seemed to be that because it has existed in state law, and I'm sure even Commissioner Harrington at the time, when he was sitting on some site evaluation committee things, there was probably a provision that is a part of the review. There was a review of the health and safety. So, yep.
If I may add?
Yes, go ahead.
The language or contributes to system reliability, that was added by the department. So because the department views the bill as technology neutral, right? We understand that everything that's on the table for the coming years is most likely renewable, and it's most likely not wood because it's not economic, right? And we don't really see anybody trying to repower oil with coal or wood with coal or something like that. It was actually added there to try and make it easier for battery systems to show some contribution to be able to get fast tracked. But if the sponsors of the bill believe that they can make a showing under health and safety for those batteries, the department would withdraw that request, right? Yeah.
Representative McGee.
I would just respond to that and say, I don't think you should. I think it's there purposefully. I think the idea is that if you have a consideration for reliability in there, then it means that the projects are going to be considered in that way, which means they may end up having that storage component or another piece. So it's saying we want to consider both, right? We want to make sure that the projects provide those things in the best case scenario. So I think the language should stay.
And again, I know I mentioned this before, but this section what we're referring to is simply what's in the application.
Yep.
And then the application has to be proven with expert testimony and witnesses and things like that. So
Yeah. Thanks.
Representative Harrington.
Yeah, but my problem is, again, it's an either or situation, and I think you want both. If that's the intent of this, is that it, and you've also got may, and if you're saying you've got to back it up with proof and everything, we shouldn't be using the word may, because may means it may show it, it may not, it's not a requirement. So you should say the applicant demonstrates that the modification will result in a qualitative improvement to health and safety of the state and to system reliability in New Hampshire. If that's the intent, That's the way it should be written. Because with a may, it's not a requirement. It says they may show that it's being done. So it's, and again, with the or, you could pick one and not the other. So I think it definitely needs to work.
Do you have a comment on that question?
So the purpose for having the may there and having it to be qualitative was to make it easier for the chair or the administrator of the SEC to approve or deny a fast track without any sort of litigation or argument over whether there is an actual and quantitative benefit to the state, so that applicants don't have to come in saying that we're reducing carbon by X amount and that's going to result in Y fewer cases of asthma in the town and is going to save the state X hundreds of thousands of dollars, right? That they wouldn't have to go through that type of proof just to qualify for a faster track. But whether you do that, that's certainly a policy question, right? So if you want more proof up front, that's.
Okay, Representative Reynolds.
Yeah, again, I understand what Representative Harrington is getting at, but I would, I guess, refer to the answer just given, and I don't think we want to make this change from may to shall, because it would be taking a bill that's intended to facilitate things happening and now raising the bar to, require all kinds of data and proof. And in this case, or with respect to reliability, the state of New Hampshire is not the, Department of Energy is not the arbiter of system reliability, right? That's a responsibility of the regional grid operator. So you'd be putting a burden on the Department of Energy to evaluate something that's really not empowered to evaluate.
Representative Corman.
Thank you. I mean, I interpret the may part as saying that there's a plausible argument toward the health and safety and the system reliability. And as far as whether to change or to and, I would be against that. Just take a simple scenario where there's no change to the health and safety, but a big change to reliability. I wouldn't want to not allow that to be fast tracked because it doesn't meet the and. And just to take Representative Harrington's scenario of something improves reliability but is a detriment to health and safety, maybe it gets fast tracked, but then later on is denied because of that. So it's not like we're automatically going to approve it if it's detrimental to health and safety. We're just fast tracking the application, and then maybe in fact the denial happens sooner.
Okay. Further discussion. Representative Lewicki.
In the same section, it says demonstrates. Expert testimony or assertions are not a demonstration. Turning the thing on and seeing the actual results is the only thing that can demonstrate it.
Well, it says the applicant demonstrates, and I think it basically means the application demonstrates.
But once again, an application demonstrates nothing except paper.
The application can demonstrate intent and can demonstrate with further information just how it intends to provide the improvements to health and safety or system reliability. Mike?
Demonstrating intent is not the same as demonstrating the actual performance. Every one of us here has seen various unintended consequences and consequences of things that did not go according to plan. I've spent a lifetime seeing that kind of thing.
But since this is just an application, you're never going to be able to demonstrate performance until after the application is approved and the project is built and up and running. All right, maybe a different word than demonstrate.
Comment on this, please.
Yes, Representative McGee.
I think we're having a great time here. We're trying to wordsmith this, but if you can demonstrate in the application that you are putting in a technology that does not emit, replacing a technology that does emit, then you have demonstrated that you have made an improvement to health. And that is an example that I would use, right? That is a qualitative demonstration that you have lowered the emissions of a plant. And so that is, I think, what they mean by it. That's what the language means. It doesn't mean that they're going to come in and give you a demonstration of the technology they're planning to implement. It means that they're going to give you some qualitative information about how the technology is an improvement as a result of the repurposing of the facility. That's what I think the intention of the language is. Not to give an intent, but to say the application is a place where you can make that qualitative statement about your technology.
Representative Harrington.
I think what we need to do here is first decide what we're trying to say. And I think that would make it a little bit easier, because with the word may there, it's not a requirement that it be done. So the applicant demonstrates a modification may result in, well, they can just say, we think this will result in improvements to the health and safety or reliability of the system. I mean, I don't know why we have may. To me, that's something you could be, just like was just said, you put in some type of a logic. We're replacing coal with wind, and therefore the emissions will go down. And so there you're showing the health and safety being taken care of. And then I still go back to the either or situation, or do you need it at all? What happens if they don't show that? Does that mean it can't be fast tracked unless it meets one of those criteria, or both? So you can certainly put in something that improves system reliability that's not going to improve the health and safety. It may not hurt the health and safety, but it's not going to necessarily improve it. So are we trying to say, here's two criteria you got to meet, you may have to meet one of them, or you absolutely have to meet one of them? Or would it be better to put in the negative and say, does not result in lessening of the health and safety of the state or reliability of the system in New Hampshire? And that would just prove, that would basically say we're not making things worse, or do we have to make things better? I don't think that question's being answered in this statement. It kind of leaves it hanging.
It probably means that you have to meet one or the other or both. That's probably what it means. Representative Kennedy.
Yeah, thanks. You know, a small nuclear reactor would increase reliability and health and safety if it was replacing a coal plant. But the whole point of this thing is wind and solar, even though those words do not appear anywhere. I mean, this is what I said during the meeting. This seems to want to dance around what the purpose of this is. You know, repowering? I mean, that is ridiculous.
Okay, further comment. Looks like Representative Kennedy gets the last word on this bill. It seems to me that this amendment is not ready for prime time at the moment. It needs another draft. So I think that I will continue this executive session until a future date certain. So keep an eye on your calendar, and we will reschedule this executive session for a future date. So we're going to recess this public hearing, executive session on Senate Bill 451. And in the meantime, we will try to create a new amendment. And Representative Munns, I would like to enlist your aid in crafting new language for page 5 on line 2 and 3, the bolded text, which is really confusing language. And also for line 33, where the same text that you use in line 2 and 3 should go in line 33. So could you help create new text for that? I'd appreciate that. And Representative McGee and I will submit to OLS the changes that we have identified that need to be made to this amendment, and ask for a new amendment, which we will consider the next time we meet in executive session on this bill. Okay.
So I'll just feed my language to the two of you.
Yes, please.
Okay.
Okay. Now let's move on. I'd like to open an exec session on Senate Bill 540. And I'd like to recognize Representative Bernardi for a motion.
I move interim study.
I recognize Representative Kennedy.
I second the motion.
Moved and seconded that we refer Senate Bill 450 for interim study. 540 for interim study. Discussion. Representative Bernardi.
Yes, looking at the bill, the great bulk of it discusses utility scale energy storage. That is not the province of the Department of Energy. That's the province of ISO New England. And therefore, only part of the bill, in my mind, appears relevant for any kind of further study, which would be that battery storage or battery capability that would be relevant to residential or maybe small commercial customers, for looking at what value behind the meter energy would be. And there's nothing in the bill that says what we're going to do with that information when we get there. So I think it really requires some kind of study to see if there's any value in doing this at all.
Okay, further discussion. Representative Corman.
Thank you. I feel that behind the meter storage and utility scale storage are extremely important to our energy future. I mean, we talk about reliability being key, and storage is one way that we're going to be achieving that going forward, especially as we go toward renewable sources. The bill does actually talk about things that can be done. I mean, I'm just looking at line 14, how best to encourage both utility and non-utility investments in energy storage projects. So it can actually result in some really good ideas that utility and people like me, I actually do have batteries now, can actually put into action. I would also point out that, as we think about batteries, the battery technology of today is not the battery technology we're going to see in a few years. In terms of energy, it seems that the fastest technological changes happening in batteries. The batteries that I just put in my house 2 weeks ago are going to be obsolete in a few years because of the improvements, right? It's not going to be lithium ion. It's going to be solid state. It's going to be iron. And I think it would be really good for the state to actually be ahead of this and be able to understand where batteries are going so that we can have reliable storage and reliable energy. So I'm going to be voting against the motion, and I actually like the bill.
Okay, further discussion. Representative McGee.
Thank you, Mr. Chairman. I'd have to echo what my colleague, Representative Corman, just said, and also say that if we opted to move SB 540 forward, then we would not have to move forward Senator Avard's bill that would be modified to only storage, because it would be covered, I think, in some of the questions that we're asking here that be responded to in this Department of Energy investigation. This also goes into things like regulatory changes and challenges with the utilities. And what it does is it prompts us to have the kind of conversations that we need to have to get to the infrastructure changes that would be needed to support adoption of renewable energy sources. So these things are, I look at them as impediments to the investments that people would be making if they had the answers to those questions. So I really do think it is incumbent upon us to at least investigate those things and get those answers so we know how to move forward. I think a lot of the, again, impediments that need to be removed are in the realm of upcoming technology and things that we don't understand. And I think this bill covers both of those. And I think we kind of owe it to our constituents to get more knowledge on it so we can make better bills.
Representative Lewicki.
Thank you, Mr. Chairman. My personal background is in the electronics industry for starting in 1966. And for every part of that time, the good batteries were always right around the corner, and they still are. We've made incremental improvements. We did NiCad and replaced some lead acid. We did nickel metal hydride, was another technology that was a little bit better. Lithium ion is significantly better. However, none of them are the revolution that we've been promised for 60-some years.
Thank you. Representative Kennedy.
Thanks, Mr. Chairman. This is kind of a general question since I'm still fairly new here, is why do we have to write laws to do something like this? I mean, can't somebody just ask the Department of Energy to do this? I mean, we seem to write laws. I mean, the last thing we were talking about was basically a law to tell the Department of Energy to make a plan to have a plan. I mean, anyway, this to me just looks unnecessary.
Representative Harrington.
Yeah, well, the term gets used in here quite a bit, utility scale. I'm not quite sure what's meant by that, but I'm assuming it means something to do with the utilities. So are we going back to the pre-structuring days when now we're going to have utilities putting up huge battery storage facilities and basically getting back into the generation business to some extent? Are they going to be buying power and putting it in there? Is the next step they'll be producing their own power to store their batteries with? And that's a major change in our philosophy of allowing markets to do this. I think the best people for pursuing modern advanced technologies are the people who are willing to spend their own money on it, whether they be private individuals or the utilities. We don't need the state to try to steer them in the right direction because, to be quite honest, we don't know exactly what that direction is. Someone who deals in that business day after day and knows all the ins and outs of it is the one I want making those decisions, not a bunch of people sitting around their desk in this room.
Okay. Representative Reynolds.
Thank you, Mr. Chairman. I think Representative Kennedy and Representative Harrington make some good points, as well as my colleagues, Representative Corman and Ranking Member McGee. But I think that the approach that we need, and the Department of Energy, if we ask them to undertake a study here, they don't need to become experts. They shouldn't actually concern themselves very much with becoming experts on technology or arbiters of technology, what is good and what is bad, etc. What our Department of Energy and our Public Utilities Commission have dominion over is the role that storage may play in enhancing reliability and decreasing costs for all ratepayers, and that would be the rules and the incentives under which energy storage could play in the New Hampshire market. That is our responsibility and their responsibility, and I think it would be useful to have them get up to speed on things like time of use rates and other aspects of the evolution of the grid and the role that storage can play. We should get more up to speed on that. We don't need to worry about what the technology is, what the best technology is. As Representative Harrington says, the market will take care of that. But right now, New Hampshire has sort of no or nowhere in terms of inviting innovation in the market, because there's no recognition of storage in our rates or anything else. So that's what I would say.
Representative Kennedy.
Yeah, as I understand, the Department of Energy is not a very old department. So, I mean, does it have a mission statement or something? I used to think that laws were general. You would have a department or whatever, and maybe a few pages about what it is they're supposed to do. And then once in a while, I guess you could have some kind of review or whatever. But we seem to want to write down exactly what we want all these departments to do. And we lack expertise. So I would think that, the department, I mean, I would think if the Department of Energy is not doing this kind of thing, then it's not doing its job, or we haven't defined its job well enough.
Well, I'd like to make a few comments about this bill. I see 5 major problems with this bill. The first one is it costs $250,000 to ratepayers, which may not seem like a lot of money, but when you keep adding 250,000 here and 250,000 there and 500,000 there, it adds up. So I don't really see that it's appropriate for us to be adding to what the citizens of New Hampshire are paying on their electric bill every year if we can avoid it. Secondly, as Representative Bernardi mentioned, utility scale storage is an ISO New England concern. It's not something that the state needs to get involved with. Thirdly, this bill purports to seek out reasons why there are hurdles for the adoption of energy storage. Well, it's pretty clear that the 2 primary hurdles to the adoption of energy storage are financing, paying for it, and the materials that are used to build these things. Why do we need to study that? It's pretty obvious what the major hurdles are to the adoption of batteries. Another reason this bill is inappropriate is it's not government's job to encourage investments in anything, any kind of technology. It's up to the private sector, the people who are actually going to finance this stuff. It's up to them to figure out how to make those investments in a way that allows them to enjoy some kind of a return on their investments. And then the final thing that's wrong with this bill is that it's pretty vague. Its requirements are pretty vague. On line 14 on page 1, for example, it says how best to encourage both utility and non-utility investments in energy storage projects. What does encourage mean? Give them a pat on the back? Give them a gold star if they figure something out? On line 19 and on line 21, it uses the word program, but it never defines what kind of a program that they want to discover best practices for or the implementation of. On line 7, it talks about the department shall investigate ways to facilitate both behind the meter and energy and utility scale storage. Well, facilitation is a public policy, and I don't think it's the department's or government's role in general to be facilitating something that needs to be done and owned by the private sector. I think this bill is totally unnecessary for those reasons and others. I could go on for a long time about why this bill is no good, and I think we should just refer it for interim study and then talk next fall about whether we actually want to look at studying this bill. But it's not the kind of bill that we should be passing at this point in time. Representative Summers.
Mr. Chairman, question for you. Because of those those items that you had just spoken, would I be out of place to make a motion to recommend ITL for this bill instead of interim study?
We have a motion on the floor of interim study. We would have to vote on that and see what the outcome was first. So we will do that. Representative Partial.
Thank you, Chair. And I take every one of your points very seriously. I think they're very well considered. But at the same time, we had House Bill 1465. We got a nice little book out of that telling us the direction that nuclear energy should take in the state. And yet, much of your criticism, doesn't that apply to that bill also? As far as, we're not going to implement it. It's out of our WIC to implement any, we're not paying for it. And it did create a significant hole in our budget. That's in order to even look at it. And it is technology that is really not for us to invest in or to So,
1465, I had to
oh, I'm sorry, yeah.
ask
yeah.
Representative Bernardi what bill that was. That's the
Yes.
nuclear study
That was a
bill?
nuclear one, which I have similar feelings on, I would think. So I was just curious to garner your opinion on that.
Well, the nuclear study bill didn't spend any money that wasn't already allocated, as I recall. So this bill does spend money, and I object to that, among other things.
That's a fair objection. I would agree.
Any further comments? Any further discussion? Representative Lewicki.
I'd make a distinction between the nuclear bill and this bill. This bill is projecting that some kind of storage that's better than what we have today will come to exist. We've got the Seabrook nuke. We know it puts out power. We know that things have moved a long way since Seabrook came online. And so, on one hand, we have the nuclear, and I will agree that there's nothing we can do to make nuclear come to New Hampshire. However, at least we're talking about a technology that's been proven.
Further discussion? Representative Munns.
Based on the strong comments that I've heard from both sides on this bill, the pros and the cons, I don't know that a motion of interim study is the right motion. I would agree with Representative Summers that we should vote down the interim study motion and then have a straight up or down vote on this bill.
Okay, further discussion, further comments? Representative Bernardi.
Thank you, Mr. Chair. Sort of piggybacking off of what Representative Parshall said, we created a study commission. We looked at nuclear energy. My initial thought on this bill was ITL, because I thought there's really nothing here that I believe is going to be of value coming out of this work. But I said, all right, there's a potential for maybe looking at value associated with batteries. So we, in an interim study group, could pull out those things which are truly under state control, not ISO New England control, and potentially advance those efforts. But similar to like the report that was put out on nuclear, we could put out a mini report or have one done on what the status of battery is, if that's an option going forward. Hence the motion for interim study. But again, my thrust would be, if left to my own devices, I'd ITL this. But I want to be open and inviting to those that think there's some merit here to at least pull out what could be of merit.
Representative Kaplan.
Yeah, thank you. I have to agree with Representative Bernardi. I think there is potential merit in looking at battery storage, and there might be flaws with this bill, but I think the intent is valuable. And if we are concerned about grid reliability, and I know that's something that we're concerned with, we know that battery storage can help with that. We know that it's going to be part of transitioning to renewable energy, and so there are definitely ways we can look to make our state more amenable to bringing more of battery storage on, and whether that's behind the meter or utility scale. And even though utility scale is ISO New England, I don't think it's beyond the remit of our Department of Energy to be looking at ways to bring that on. That's to the benefit of our constituents. So yeah, I'd be in favor of at least looking at interim study for this.
Further comments? Okay, seeing none, I'm going to ask the clerk to call the roll on the question of the adoption of the motion of refer for interim study on Senate Bill 540.
Vice Chair Thomas.
Yes.
Representative Nodder.
Yes.
Representative Harrington.
Yes.
Representative Lewicki.
Yes.
Representative Melvin.
Yes.
Representative Bernardi, yes. Representative Ploget.
Yes.
Representative Summers.
Yes.
Representative Kennedy.
Yes.
Representative McGee.
No.
Representative McWilliams.
No.
Representative Partial.
No.
Representative Kaplan.
Yes.
Representative Munns.
No.
Representative Noel.
No.
Representative Thomas.
No.
Representative Corman.
No.
Representative Reynolds.
No.
Chairman Bose.
Yes.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 to 1, 2, 3, 4, 5, 6, 7, 8. 11 to 8.
Okay, by a vote 11 to 8, the motion to refer for interim study on Senate Bill 540 is adopted. And Representative Bernardi will write the calendar report. Will there be a minority report? Representative McGee?
I would like to write one for OT.
Representative Corman will write the minority report. And if you could have that ready for us before you leave today, that would be appreciated. Okay. With that, we'll close the exec session on Senate Bill 540. And that brings us to the close of our business for today. I'd ask you all to reserve next Monday, the 22nd of April, for a committee session. It will likely be an executive session, maybe a work session and an executive session on the 4 bills that we heard earlier today, plus we still have work to do on Senate Bill 451. So keep next Monday, the 22nd, open.
Are we gonna meet-
Representative Thomas?
Are we going to meet in the morning? Or
Yes,
is-
yes,
okay.
we will start in the morning, yes.
I'm going to need a stop.
Anybody else have anything they would like to discuss with the committee before we go? Representative Summers. Use your mic, please.
Next week is school vacation week for the state of New Hampshire, in case anybody conflicts with anybody. That's all I was gonna say.
Okay. I'll try to remember that, but probably still going to schedule a committee meeting that day. So if you could work that into your school vacation plans, that would be appreciated. Okay, anything else? Okay. It's Earth Day as well, that's true. All right, thanks, everybody. We'll see you next week.